Letter for eligible order number one. I think they want particular 2021.
Dismiss.
Obliged.
May it please your lordships. My lord, item number 27, my lord.
Yes.
In this case, I would like to withdraw this petition, liberty to file fresh petition.
Let's get the third item. And see also some statistics in the party. And the petitioner may be allowed to approach this for the gate by pen. There is accordingly allowed. Dispose of on withdraw.
Obliged.
Liberty of the image of the-
Obliged. My lord, this matter may be listed for motion on Wednesday, my lord.
What does that?
Yes.
Okay.
This matter was fixed for today. The suspension matter, BTC area, my lord. Was it fixed this matter today, my lord? But it was not listed. Can be listed tomorrow, my lord? Obliged, my lord.
Maybe, lordship, I'm praying for listing an urgent motion tomorrow, lordship. The urgency is that, lordship, the government has come.
Hearing day.
Wednesday, lordship. Okay.
May it please my lord, prayer for listing of a motion matter on Wednesday. I am deeply obliged.
My pleasure, Lordship. Lordship, one matter listed on February 23, another was listed on 24 September. So may I pray for listing the matter next week, any date?
So one matter is fixed on 24.
No, last listing was February 2023. Lordship.
You have two matters. Or one matter.
Two matter, Lordship.
When do you want?
Listing next week, any date? Bench 2. Admission, one is for admission, another is for order.
If it is admission matter, then after the motion matter, if it is
Orders,
matter, then-
another is order matter.
May I please, your lordship, for prayer for listing, lordship, for admission, lordship.
when
Lordship 15, 10 or 15, lordship, any
is
day.
there any urgency?
Urgency, yeah, lordship, for retirement benefit matter relating to lordship. Two matters.
Expect it on
27 September. Two.
27.
May it please,
Matters, lordship. Two matters.
One on 22nd, one on 24th.
may it please your lordship. I beg to mention item number 20, my lord. In item number 20, the department filed an affidavit in opposition. We need to file in our rejoinder, my lord. Fixed time needed, my lord. Item 20,
when do you want?
after 3 weeks, my lord.
For the hearing matter, start, I say started. The matter is the adjourned to be listed after 3 weeks.
Highly obliged.
May I please, lordship, I beg permission for listing of the petition, lordship. Whereas the present petitioner from the
But
last
what?
19 months, they are not getting the salary, lordship. And the coming is puja vacation, lordship.
When
So
do you want?
Thursday or Friday, lordship.
Friday is always a.
And it is notice was already issued, lordship. And Wednesday. This week maybe, lordship, and any date, lordship. This week, lordship, salary matters, lordship.
Yes, madam.
May I please, your lordship, lordship, I want to mention regarding listing of two read petition for admission, lordship, on Monday. Matter pertains to, one is non-payment of salary
Or motion.
for admission, lordship.
If there is
Lordship, actually,
admission matter after vacation,
urgency is that, lordship, she is not getting her salary, lordship. She retired in the year 2021. It was last listed in April of 2024, lordship.
take it immediately after reopening.
Lordship, on 22nd, lordship, can,
Lot of matters have been taken.
13th October.
Yeah.
Obliged.
Say with the consider other side, I'd like to mention item number 31, my lord.
21.
31, my lord. Lordship, due to some personal difficulty, I have to leave now, my lord. So may I pray for listing it on day after tomorrow, my lord. I have taken the consent of others.
Tomorrow is hearing day.
Day after tomorrow, my lord.
Day after.
Day after tomorrow.
Hearing made by Mr. R.R. Kothari, Garnet, at 8. The matter is scheduled to on Wednesday.
Wednesday.
If I may, Lordship, we have no objection, but we were under the impression that they have received your instructions and
Yeah, I have received the
they will
instruction,
be.
my lord.
Your Lordship may kindly report that submission before
Yes.
Lordship. As regard to receipt of instruction.
Today,
Yes, Lordship.
No, anyway, I am going to place it, my lord.
No, Lordship, we were under the impression that they will be mentioning this matter because they have received the instructions and they required some time.
day after tomorrow, we will
Yeah.
consider it.
Yes, my lord. I have received the instruction otherwise.
Have your blessed. Lordship.
So I pray for listing of petition for orders or any date, Lordship, before vacation. 9.
But with the
Public.
lordship, lordship, I beg to mention for listing of a contempt matter, lordship, for orders. Next week, lordship,
When?
next week. Obliged, lordship.
For motion item number 2.
My lord, a contempt matter listed for the first time, your Lordship may issue notice.
Part with R.R. Kothari, Garnet, Sir, T dash Garnet for the petition. This petition under section 12 of the contempt of body. Schedule article. 15 of the Constitution. Yeah. Is prepared by the petitioner for willful and deliberate violation of the judgment within 16/5/2025 not without number 3864 of selection and WS. Is it a common order?
My lord.
And WS number 6604 of 2020.
Op-
Uh, 3864 of 2017 and WS number 6604 of 2020. Then notice page to the respondent conduct not returnable for which step be taken by registered both with ADN or the process. Is no from today. After 4 weeks.
Obliged.
Item 3.
Please, the Lordship. This is against for non-compliance of the order dated 28/04/2025 passed in WVC 4910 of 2024, Lordship. May kindly come to page number 16, Lordship. Para 34 and 35, which contains the effective portion. In view of the foregoing discussions, I am of the considered view that the respondents are deserved to be directed to consider the case of the petitioners for according permission and allowed to conduct admission for the higher secondary first year class and onwards in their respective schools. Accordingly, the respondent authorities, namely the Secretary to the Government of Assam, Secondary Education Department and Director of Secondary Education Assam, as well as the AISSEC are directed to consider the case of the petitioners within a period of 3 weeks, Lordship. And based on this, my writ petition was allowed and I communicated it. And the communications have been placed in record from page number 18 onwards, Lordship.
Okay. Art Mr.
M. Raman.
For the. So under section 11 and 12 of the content from protect regulate article. Is prepared by the petition. For willful and deliberate violation. And for non-compliant order dated 28. caused by the school in WP number 4912 of the. Where is the petition? The order is for the right. That topic page should not respond. Return evidence for specifically taken by registered courts with alien also in the process. Is subtract for
Highly objective.
Item four.
May it please your lordship. My lord, this matter relates to compassionate appointment, my lord. The DLC decision is at page 42, my lord. Page 42, serial number 11. Here instruction was sought, my lord.
the data bill was disposed of.
Lordship? No, Lordship. It is still pending and fixed on 14/10/2025, Lordship.
1410.
Your Lordship.
So let us say after disposal of the data bill.
Yes, my lord.
Third message. Work for the respondent to occur. The element we have to get part. For this. The order passed by. Data bill number. Date of the date. And the next step of the appeal has been fixed on 10, 14, 10, and 5. Accordingly, this is after
May I please your Lordships?
Lord, my friend, Lord, for VTC has filed affidavit today itself. So let it be posted after a week's, Lord, with the Lord affidavit filed by my friend. PTC authority.
Lordship, we are going to file it today, Lordship. Copy has already been served to them. Lordship,
or
PTC.
total burden. Your name, please.
Lordship,
Your name.
S. Boro, on behalf of RB Bora.
It's for burden of RB Bora. Learn it. Something for the. During the course of the day, and to best for this amendment, when
After a week.
after a week. Accordingly, provided like this.
Obliged.
Lordship, kindly pass on the matter for time being.
Item 7.
May I please, your lordship? Yeah, lordship, this is the second round of litigation, lordship. Matter relates to compassionate appointment, lordship. In compliance of the earlier direction of this honorable court, the district level committee recommended the name of the petitioner that lordship will find at page 38. The meeting was held on 19/9/2023. My name is at serial number 13. Recommended for assistant teacher, lordship. So while the matter was pending.
Name is serial number.
Serial number 13, Arif Ahmed Majumdar, serial number 13, page 38. In the remark column, WC number so and so, order dated 11/4/2008, Lordship. So ultimately, Lordship, while the matter was pending before the state level committee, in view of the direction of the notification of Your Lordship is aired at 18/9/2024, the matter is yet to be considered. But during pendency of these applications, Lordship, this Honorable Court on 3rd of April 2025, direction is given to consider all the pending cases. Now, in terms of this notification of, order dated 3/4/2025, now the state government in the Personnel Department, they have issued a notification on 30th August 2025, whereby direction is given to candidates whose cases are pending to submit their all particulars by the end of 15th of September 2025. In similar cases disposed on 1st of September 2025, taking note of those notifications as well as the court's order, Lordship. May I, Lordship, submit a copy of that order? The same order may be passed, Lordship. Thanks. My learned friend was on that day. This was issued on 13th, the last paragraph. Let's kindly have the page, paragraph number 3. 2 and 3, same grievance, Lordship. Petitioner submits that case of the petitioner is also squarely covered by the said decision, that is 3rd of April 2025, passed in batch of writ petitions. He also submits that pursuant to the said decision, the state government in the Personnel Department have come up with a notice dated 30/8/2025 by directing all similarly situated applications to submit their details to the office of the Secretary to the Government of Assam, Personnel Department on or before 15/9/2025. He does submit that petitioner may also be allowed to submit her details.
Where is that notification?
Notification, I'm having a copy. And so there's a handwritten letter. But notification. Then it was published in the newspaper, Lordship. Assam Tribune and the Assam. 33rd. Direction is given to submit all particulars along with the court's order by the end of 15/9/2025. The last paragraph, Lordship. After 15/9/2025, they have indicated that no applications will be again considered. So, Lordship, in terms of this order, my case may also be disposed of, because earlier, Lordship, there is a court's direction, and in view of 3rd of April 2025, I am entitled for consideration. And subsequently, because of this notification, also I'm eligible to apply, Lordship.
Lordship, what it transpires is that at page 24 on 11/4/2008, already an order was availed by him. So which wherein direction was there that existing guideline mentioned above, her case for appointment shall be considered by the author within a period of 3 months, Your Lordship. Way back in 2008, Your Lordship. Way back in 2008. Now thereafter, again, in the year 2023, she comes with a fresh application, Your Lordship. So from 2008, since the schemes about the essential criteria is that about the harness and immediacy. Harness and immediacy, Your Lordship. So since after 2008, no any sort of communication or no effort from her is being or their family is being seen, Your Lordship. So
This Honorable Court.
This order being passed on the 11/4/2008.
yes, Your Lordship.
Whether her petition was considered by the authority.
No, that was considered page 37. It is only in 2023. This Honorable Court on many occasions held that it is not the date from the date of consideration. My case was considered on 9th of September 2023. So therefore, I am covered by this order of 3rd of April 2025. They have considered. Lordship, kindly see there is a Lordship reference of my case number, page 38, WBC number so and so, order dated 11/4/2008.
Normally, normally honorable court's order after the direction from honorable court to consider it within the period of 3 months, your lordship. Normally, practically it seems impossible because otherwise, if it was not placed, the petitioner would have come, your lordship.
Sir, then why it was considered on 19/9/2023?
The date of consideration is crucial, Lordship, not the date of filing application, Lordship. On many occasions, this honorable court held regarding compassionate appointment, it is, as well as the apex would also, it is
That
only the date
definitely-
of consideration.
That definitely I do. That's why I'm saying, since the specific time period was there, direction was there from this honorable court to consider it within the period of 3 months, your lordship. So
But you have not considered it.
court,
As per this annexure 5, you have considered it after long weeks.
no, perhaps that developments may not have been revealed by the petitioner. That may also happen, your lordship. That may also happen.
Lordship, in otherwise also, Lordship, this.
So your lordship, let it be placed in the, but
Yes,
those
yes.
submissions of mine may be
I am
recorded.
praying for
That is what does.
Yes, yes. And otherwise also it is the department. Lordship, dispose of the problem. Lordship, that notice may be taken as a part of the record. Lordship. 30th of August 2020.
My lord, item 13 also almost similar, my lord, same, my lord, only date of
Number?
13, only DLC date is different.
Every you have checked the item number 13.
13.
DLC has recommended page 28, page 30, serial number 7.
The applicant is recommended for
The
consideration.
applicant is recommended for
Page number?
page 30,
Page number, serial
my
number
lord,
7.
page DLC minute dated 21/12/2021, page 28, and my father died in the year 2013, considered by DLC on 21/12/21, and recommendation at page 30, serial number 7.
Yeah, this one.
13. What else?
In your case, there is no order of this court.
There is no order. Directly, my case has been recommended by the DLC. Now, because of the impugned office memorandum, my case is pending before the SLC. Send, my lord.
Every
Lordship, on perusal of page number 28, the DLC, it was held in the year 21/12/2021, your lordship. So thereafter,
Page 30.
thereafter, on many occasions, the SLC was there, your lordship. It is not that the SLC was not there. More so, he has not annexed the NOK, your lordship, and whereby in the DLC also it is no examination of any sort of the financial condition or no comparison. Still then let it be placed, but that all submissions be taken into account, your lordship.
Obliged.
Wait, please, your lordship. Lordship, last occasion, lordship called for instruction.
Lordship, I will be receiving the instruction. Lordship may take it up next Monday, Lordship. They have telephonically asked me for a week's time, Lordship. I may take it up on Monday, Lordship. Come.
Thirteen, sir, 8 lakh, 13.
Move Monday instruction. Lordship.
5 cents.
And I get in with the final Monday.
And commits that. Yes. The measurement at not the insurance to negotiate to take the instruction. There is a code there, that's the method.
It's gone.
Total.
7-9.
Pass over for time limit. Time. May I please your lordship, the engaged counsel is leak on other call. Please take over that after some time, take the item after some time. 10 and 11 both. 10 and 11. 11 time lose.
11, I'm appearing, your lordship, for secondary education.
I'm being put
Take it off after some time.
May I please, Your Honor? Okay. Your Honor, I'm the petitioner. The petitioner is as an employee as a Borpata Girls College. The petitioner has find the PhD degree from the Mogoth University. After the obtain the PhD degree from the Mogoth University, his service is regularized by the MO, and thereafter, with the permission, with the appropriate procedure, he admitted on the Mogoth University for the PhD degree. After obtained PhD degree, is service has regularized. Thereafter, once one showcase has showcase issued by the respondent number 2. The showcase number, yeah, page number. Page number 37, Your Honor. First, that after received the showcase notice, the petitioner replied thus matter. Thereafter, Your Honor, respondent number 2 also served the showcase notice. Thereafter, respondent number 2 again issued notice, and fourth time, Your Honor, second showcase notice has issued by the respondent number 2. My humble submission before your honorable court, the respondent 2 is doing the harassed, the view to harass the petitioner, and again has served notice. 2 times showcase notice has issued, and 2 times hearing and another notice has issued. In this aspect, the petitioner become the harassed. So my humble submission before your lordship, please issue notice to the respondent and another respondents. And similar cases is pending before our honorable court. I have the 3 cases, similar case, which has been pending before our honorable court, and I have the order copy.
So, oh, yeah. Okay. Why two disciplinary?
Yes.
proceeding has been brought up?
Yes, on the identical truth, that's it. Identical, sorry, the questioning the validity of the PhD degree. Same issue has been taken up in other two matters also, that's it. And Honorable Court has questioned the same query, put the same query, and paid the second show cause notice while allowing the first to proceed with the first show cause notice. That's it. That seems identical because that proceeding cannot be stopped as per the Honorable Court of the observe that the initial notice may be proceeded. চাৰিখন গ'ল নেকি? একেই গৈছে, একেই গৈছে। বাকী two sets have been.
Whether both the so-called notice are part of the record?
Isn't it? Yes, one is at page 37 and second one put aside. Not more. Assess. Another is at page number 52.
52, Your Honor.
First one is initially of 26/6/2020, page 37.
Next one, right?
That's it.
Next one.
52. The PhD degree obtained is under cloud lordship by the petitioner, so lordship. So two notices were issued. So why it is also lordship will have to obtain instruction, but lordship the initial notice that is at page 37.
Sir, Robinter, you do one thing, you obtain instruction.
Lordship,
What stage the disciplinary proceeding are pending?
yeah, I can obtain instruction that also lordship. Otherwise, lordship, since Honorable Court has already stated the second new note, so cause notice, same date, initial one was also same date, and they directed that the authority may proceed with the initial one.
Maybe, even then you obtain.
Not
Because
what is the
first one may not be in detail.
a number of cases are lordship pending, same issues are there. I'll take.
Pardon me, sir.
G. Hussain.
Robinter, pardon. I- pardon. The defense thinks up to be the petitioner was appointed as lecturer in the department of
Initiation.
informed the guard to the fourth one, 12, initial 5. Yes, accordingly, the petitioner joined on the design, 12, 5, 10. 1/10/2010, the petitioner, with permission from the principal, admitted in PhD program. PhD program of about in person. About the comparing normal. And the petitioner has completed the same program and he was conferred with the PhD degree by the faculty also. Here, the service of the petitioner was in fact from 20 of the party. And while the petitioner was rendering his service, he was served with a proposal of dated 20 by the respondent of part 2, alleging that the petitioner had completed the offer with regard to his PhD. The petitioner has responded to the same scope of of this by submitting line on 4/7/2020. And he denied the charges level against him. And there disciplinary proceeding was initiated against him. And the petitioner had appeared for the inquiry of 5/11. And there the petitioner was served with another local notice that they would for number of charges out of the charges arising. The charges that against him, the arrears of notice that they 26. And being agreed, the petitioner approached this court by applying the present. With a direction to set aside the so-called notice. Dated 26/6/2020, and also the so-called notice dated 4. The submission of the learning further. And this is notice needs to returnable in 4 weeks. However, no formal notice is required before the document number. You are representing the principal of the
No lots, only 1 and 2 lots.
1 and 2, same notice are entered against however, extra requisite copy of the parts the course of the state upon document number by lesser courts with alien also by also. This after following the meantime, so public learned of the number 1 and 2. And apply this for the next.
God bless you.
Item 15.
I can take it up, may you mention my In the morning, I made a mention for listing a writ petition, This writ petition was taken up in the last Monday, Mr. Nayak, he took time for 1 week. Lordship, told that, next Monday it will be taken up. I did not verify the date on which it is fixed or not. As it was, Lordship, fixed the matter today, I made the statement that it was fixed today. Now, the court master says it was not fixed. And the matter has been directed to be posted on 13/10/25. If the very video is verified, Lordship has directed the
When it was fixed.
It was fixed today, but the date was not typed by the court master, not typed by the stenographer.
Sorry, if it is not there, then we cannot accept your submission.
If the video is verified,
Sorry.
then Lordship will find that it is fixed on Monday.
Yes, next.
Item 15.
15 to advocacy.
My lord, this is third round litigation, my lord. This is third round litigation of the petitioner, my lord. Service of the petitioner was regularized in the year 2020 after continuous service of 25 years, my lord. And now, by the order dated, my lord, 22/8/2025, that has been cancelled. Not only cancelled, my lord, her service is also dispensed with, my lord. Directly to be dispensed with, my lord. The background of the case is that, my lord, the petitioner was initially appointed in Borveti Girls High School when it was a cancer school, my lord. And she was appointed by the managing committee in the year 1990. Thereafter, my lord, during the in the year 1992, my lord, Government of Assam has created, my lord, 500 posts under a centrally sponsored scheme. And one post was, my lord, attached to the Borveti Girls High School. And the petitioner was appointed against that school in the year 1995, my lord. and in fixed pay, my lord. During the, my lord, 9th plan, my lord, central government withdrawn the scheme, my lord. And thereafter, my lord, government of Assam conducted a screening test in the year 1998 by issuing a notice, my lord. And thereafter, my lord, government has created 401 numbers of posts with effect from 1999 and abolished the earlier 500 posts, my lord. And out of the 401 post, my lord, one post was allotted to, again, my lord, Gorveti Girls High School. And against that, my lord, the petitioner was appointed by second appointment letter dated 12th July 2000, my lord, issued by the director of the secondary education, my lord. That is annexation 9 case 57. Thereafter, my lord, all the posts were permanently retained by the order, my lord, passed on 3rd August 2004, that is annexation 11. And my lord, the petitioner, along with 81 other Hindi teachers, my lord, they were appointed in Cancer School, my lord, by the government, my lord. And other, my lord, 319 posts were allotted to Provincial School and they were appointed in Provincial School, my lord. And the Hindi teachers who were appointed in Provincial School were allowed, my lord, regular scale of pay. And the Hindi teachers, like petitioners, total 82 teachers were appointed in, my lord, Arab School, Cancer School. They were allowed only fixed scale of pay. Being agreed, my lord, some of the, my lord, similarly situated Hindi teachers, my lord, approached this honorable court in the year 2005, my lord. And this honorable court had ordered that, my lord, 4/3/2005, directed the respondent number 1 to consider the case of those petitioners, my lord, sympathetically. Thereafter, my lord, the respondent number 1 passed an order, that is, my lord, annexure 13, my lord, page 65. The relevant portion is, my lord, page 66, my lord, may I read, my lord. By this order, my lord, the respondent number 1 decided to adjust those 82 Hindi teachers, my lord, in future vacant posts, but rejected their claim of regular scale of pay with effect from, my lord, 1/3/1999. And thereafter, my lord, out of the 82 Hindi teachers, my lord, 76 teachers have been already adjusted against the sanctioned vacant post in the provincial school in the year 1999. But when, my lord, on 2/8/2006, the petitioner was transferred from the original Cancer School, my lord, Gorveti Girls High School, my lord, to, my lord, Polastol Kasomari High School, which is a provincial school, my lord. And she joined on the next date on 3rd August 2006. And since then, she did not receive, my lord, the salary against her post, my lord. And, my lord, thereafter, although several communications were made for adjustment of the petitioner along with 5 others left for adjustment or regularization, my lord, but it did not reach logical end. And thereafter, in the year 2013, my lord, an advertisement was published by the, my lord, headmaster of Polastol Kasomari High School for filling up the post against which the petitioner was, my lord, transferred. Then the petitioner approached this honorable court by filing WPC numbers 3779 of 2013, my lord. And then initially, my lord, that advertisement was paid, and finally dispose of this writ petition, my lord, with a direction to the respondent number 1 to pass a speaking order regarding regularization or adjustment of the petitioner against, my lord, sanctioned vacant post, my lord. But rejected the claim of her arrear and current salary. Then being agreed, my lord, the petitioner filed one writ appeal, my lord, that is WA number 19 of 2017. And the petition, during pendency of that, my lord, writ appeal, the respondent number 1 has passed, my lord, an order, that is, my lord, annexure 22, dated 24 January 2017, whereby the claim for, my lord, regularization was rejected on the ground that she is not having the TAC qualification. And that was assailed in the writ appeal by amending writ petition, writ appeal, my lord, with leave of the honorable court. But when my lord writ appeal was disposed of, a direction was issued the state respondent to release the arrear and current salary with effect from 3 years prior to filing of the writ petition, my lord. And the petitioner was given liberty to assail that, my lord, order whereby my lord rejected the adjustment and regularization of the petitioner. I'd order that 24/1/2017. That is, my lord, relevant portion, page 99. And the direction of the honorable division bench, my lord, passing writ appeal number 19 of 2007. Thereafter, my lord, the petitioner filed another writ petition assailing that order, my lord, on the basis of liberty given by the honorable division bench of this honorable court. That is, my lord, writ petition number 5440 of 2018. And during pendency of this writ petition, my lord, the director of secondary education has regularized the service of the petitioner by, my lord, an order that is, my lord, at page 103, my lord. Kindly see 27 May 2000, my lord. 103. My lord. And her service has been regularized with effect from immediately from, my lord, 27 May 2020 against sanctioned vacant post, which was fallen vacant on 30, my lord, April 2018. Accordingly, my lord, Director of Secondary Education filed an affidavit stating that her service has already been regularized. That is, my lord, Annexure 26, relevant page 106, paragraph 5, my lord. Page 106, my lord, relevant paragraph 5, my lord. With regard to query regarding regularization of services of the petitioner, the deponent humbly begs to state that the services of the petitioner were regularized or adjusted as Hindi teacher in Polastol Customary High School by order dated 27/2/2020 with effect from 27/5/2020, and also directed to draw her salary with immediate effect. And, my lord, on the basis of this submission, my lord, this honorable court has disposed of the writ petition WBC number 5440 of 2018, Height Annexure 27, my lord, dated 19/7/2023, my lord. The lordship may kindly turn to page 112, my lord. Relevant paragraph is 11, 12, 13, my lord. Married, my lord.
11 paragraph.
Paragraph 11 to 15, my lord. Page 112. By filing an additional affidavit on 13/3/2023, the respondents in Education Department through the Director of Secondary Education Assam clarified that I'd ordered as a change so dated 27/5/2020, the service of the petitioner as a Hindi teacher has been regularized in Polastol Customary High School, District Nogao, with effect from 27/5/2020 against the vacant post number so created on 16/11/1991 and permanently retained by number so dated 7/6/2004, where the vacancy occurred on 30/4/2018, and that she will continue to receive her monthly salary with effect from 27/5/2020. Since the service of the petitioner has already been regularized by order dated 27/5/2020 as a Hindi teacher against a regular sanctioned post in Polastol Customary High School, District Nogao, the prayer made by the petitioner in this writ petition has already been considered. The respondent authorities in Secondary Education Department of the state, in pursuance of the judgment and order dated 25/1/2018, passed in WA number 19 of 2017, shall pay the regular salary to the petitioner with effect from 1/7/2013 forthwith, if not paid in the meantime, complying with the said direction of the court dated 25/1/2018. In addition to the above, the respondents shall also continue to pay regular salary to the petitioner in terms of order number so and so dated 27/5/2020 of the Director of Secondary Education, Assam regularly, with effect from 27/5/2020 without fail. Copy of the order number so and so dated 27/5/2020 of the Director of Secondary Education, Assam, placed before the court today by Mr. Khonikot Khatoniya, Learned Standing Council, Secondary Education Department, be kept as a part of record. Needless to say that the authorities in the Secondary Education Department have not cleared the arrears salary of the petitioner in terms of judgment and order dated 25/1/2018 of the Honorable Division Bench passed in WA number 19/2017, as well as in terms of state order of the Director of Secondary Education, Assam, dated 27/5/2020. The petitioner at first shall bring it to the notice of the Commissioner and Secretary to the government in the Secondary Education Department of Assam, and also before the Director of Secondary Education, Assam. In spite of that, if those authorities did not comply with the direction of this court noted above, the petitioner shall be at liberty. The petitioner shall approach the appropriate forum for redressal of her grievances. My lord, thereafter the petitioner has filed representation before the Commissioner, Secretary, and Director at Annexure 28, my lord, to, my lord, release the area and current salary, my lord, since it was not entirely, my lord, cleared, the release, my lord. Thereafter, my lord, a notice was issued to the petitioner, IS, and headmaster, my lord, that is Annexure 29, my lord, page 122. To attend the petition, attend the office of the, my lord, Joint Director of Secondary Education on 7/9/2024. And accordingly, petitioner, my lord, appeared before the Joint Director of Secondary Education, my lord, and all the documents have been verified on that day, my lord. Now, my lord, the impugned order is, my lord, Annexure 30, page 123, my lord. By this order, my lord, the earlier regularization order has been cancelled, my lord, which has already been attained finality after passing the order on the basis of that regularization order by this honorable court, my lord. And that has been done without, my lord, leave of this honorable court. And that has been done, my lord, without issuing any so-called notice or, my lord, without affording proper opportunity of hearing, my lord. So, my lord, that it is absolutely, my lord, illegal, my lord.
No, notice was issued to you.
My lord.
Notice was issued to
No,
you.
my lord, only attend the hearing, no so-called notice, my lord. What was the purpose? Here, my lord, it is stated that, my lord, hearing along with all relevant records, documents in connection with the claim of regularization of service. Already regularized, my lord.
Your Lordship,
No claim is pending.
verification has already been done, Your Lordship, by conducting hearing, Your Lordship. Thereafter, Your Lordship, that speaking order has passed, Your Lordship. So, Your Lordship, opportunity has given, Your Lordship. Opportunity has already been given, Your Lordship, for verification of the documents. And Your Lordship, thereafter, Your Lordship, the impugned order has already been passed.
Why disciplinary proceedings was not brought up against her?
Let the notice may go.
And my lord, if your lordship will go to the order, my lord, your lordship will find that, my lord, in page 126, my lord. Therefore, the order number so and so dated 27/5/2020 of regularization adjustment of service in respect of Srimati Beauty Deka as Hindi teacher of Polastal Kasamare High School under Nagaon district is hereby recalled and cancelled. Further, the inspector of schools, Nagaon, being the appointing authority in respect of assistant teacher, is hereby directed to take necessary steps to dispense of service of the Beauty Deka, my lord. There is no cause, no so-cause notice in this regard, my lord. And I am continuing in service, my lord, since the year 1995 against the sanctioned vacant post, my lord. Initially, that was, my lord, under centrally sponsored scheme, and thereafter, my lord, against permanently retained, my lord, post, my lord, created by the government, my lord. And subsequently, all other, my lord, similarly situated Hindi teachers have already been adjusted, my lord, on the basis of the decision taken by the government to adjust them against sanctioned vacant post in Polastal Kasamare High School, against my lord provincial high school. And I am serving since the year 2006, my lord, against sanctioned vacant post, my lord, only by dint of my lord transfer from my earlier post to present post, my lord. So, my lord, all along I am serving, my lord, against the sanctioned vacant post and continuously serving without break, my lord, for last 30 years, my lord. So, if my lord, my service has been terminated by this way without issuing so-called notice, my lord, without following due procedure of law, my lord, I'll be, my lord, deprived from the service, my lord, without, my lord, following due process of law, my lord. And so, my lord,
Already, your lordship, in the findings itself, your lordship, that is on page 124. Your lordship, one government letter that is highlighted to sixth highlighted point, your lordship, government wide letter dated onwards, page 124.
may I read, my lord, the entire finding, my lord, because entire findings
Your lordship,
reflects, my lord.
Your lordship, you already
relevant.
submitted, your lordship. Kindly, your lordship, I would like to take your
Starts at page
attention.
Let him complete.
My lord, page 123, my lord, in extra 30. Your lordship may kindly see the entire, my lord, order, impugned order, my lord. Here is the government letter number so dated 4/5/2024, whereby it is directed that if the incumbent continues to serve taking advantage of ongoing departmental correspondences, which will consume time, then finally she will be eligible for salary again. In this regard, you are requested to dispense with her services immediately by issuing a speaking order with the findings or stand by the order already issued. Also peruse the report of the hearing in connection with regularization of service of Srimati Beauty Deka, Hindi teacher of Polastol Kasamari High School under Nagaon district, conducted by Joint Director of Secondary Education Assam in presence of the following person: the Inspector of School, Headmaster of Polastol Kasamari High School, Srimati Beauty Deka, Hindi teacher. Finding: Srimati Beauty Deka was originally appointed as Hindi teacher by the Managing Committee of the then Bhansar Poverty Girls High School under Nagaon district by resolution dated 21/7/1990. In the subsequent period, the government by letter dated 16/11/1991 created 500 posts, 300 numbers graduate and 200 numbers intermediate posts of Hindi teachers under centrally sponsored scheme. Srimati Beauty Deka was appointed as Hindi teacher, senior grade ad hoc, on ad hoc basis for a period of 4 months in the fixed pay of Rs 1375 per month at Poverty Girls High School, which was not provincialized at that time, under Nagaon district by the then Inspector of School, Nagaon Bhai, dated 17/2/1995. Later on, one post out of 82 posts for ad hoc secondary schools allowed in the consolidated basic pay of Rs 13580 without any incremental benefit at government letter number so dated 13/6/2000 was allotted to Borbeti Girls High School and Srimati Beauty Deka, working Hindi teacher of Borbeti Girls High School under Nagaon district, was adjusted against said allotted post height. This office order number so dated 12/7/2000. Srimati Beauty Deka was transferred to Polastol Kasamari High School in the unlawful and impracticable manner by the then Inspector of Schools, Nagaon, had order under memo number so dated 2/8/2006. And subsequently, Srimati Deka accepted the transfer and joined here. Srimati Beauty Deka did not receive her monthly salary since her joining in Polastol Kasamari High School. The post of Hindi teacher of Polastol Kasamari High School was advertised on 26/6/2013, and being aggrieved, Srimati Beauty Deka filed WBC number 3779 of 2013, challenging the said advertisement and claiming regularization of her service. Subsequently, in compliance of the Honorable High Court's order dated 1/8/2016, passed in WBC number 3779 of 2013, the government passed the order number so dated 24/1/2017, rejecting the claim of the petitioner. Writ appeal number 19 of 2017, assailing the government's order dated 24/1/17, was referred before the Honorable Guwahati High Court by Srimati Beauty Deka. Government by letter number number 19 dated 10/7/2018 issued direction to this office to submit proposal for regularization or adjustment of service in respect of Beauty Deka in terms of Honorable High Court order dated 25/1/18, passed in WA number 19 of 2007. Consequently, formal proposal as received from the Inspector of Schools, Nogao, was submitted to the government at office letter number so and so dated 19/11/2018. WA number 19/2017 was disposed of by the Honorable Court by the order dated 25/1/2018, whereby respondents were directed to pay salary or remuneration to the appellant as admissible under rules from the period commencing 3 years prior to institution of the retribution on 1/7/2013. After certain communication, the government the government had letter dated 4/2/2020 directed this office to examine the matter and instructed that while regularizing adjusting the service of Beauty Deka, the case of 76 numbers of similarly situated ad hoc Hindi teachers who were regularized should be taken into consideration. It was further informed that if it is decided to regularize or adjust her service, it would result in closure of pending petition number 5443 of 2018, otherwise to file affidavit in the said case. Again, the government had another letter dated 4/2/2020, directed this office to comply with judgment and order dated 25/1/2018, passed in WA number 19 of 2017, by releasing her salary with effect from July 2010. That is from the date of commencing 3 years prior to institution of petition, filed on 1/7/2013, in terms of the order of Honorable Division Bench. Subsequently, the service of Srimati Beauty Deka was regularized, adjusted as Hindi teacher in Polastol Kasamari High School, District Nogao, against vacant post occurred on 30/4/2018. Had this office order number so and so dated 27/5/2020. Thereafter, Srimati Beauty Deka received her first salary for 6 months on the date of her regularization adjustment as Hindi teacher at Polastol Kasamari High School, Nogao. An amount of rupees 6,47,615 as arrear salary for the period which effect from 1/7/2010 to 30/6/2013 was sanctioned to Beauty Deka, Hindi teacher of Polastol Kasamari High School, District Nogao. While the online proposal for releasing first salary of Srimati Beauty Deka was moved, the government raised objection on issuance of regularization adjustment order in respect of Sri Beauty Deka issued by his office order dated 27/5/2020. And accordingly, government by letter number so and so dated 4/6/2024 issued direction to this office as under: if the incumbent continues to serve taking advantage of ongoing departmental correspondences, which will consume time, then finally she will be eligible for salary again. In this regard, you are requested to dispense with her services immediately by issuing a speaking order with the findings or standby order already issued. After careful examination of available records as well as report of hearing, etc., it appears that the transfer order of Beauty Deka while she was rendering her service as at ad hoc Hindi teacher at Borveti Girls High School, Nogao, to Polastol Kasamari High School, issued by the Inspector of Schools, Nogao, by the order under memo number so and so dated 2/8/2006, without prior approval from the higher authority is itself irregular or illegal. The regularization adjustment of service in respect of Beauty Deka as Hindi teacher of Polastol Kasamari High School under Nogao district, issued by number so and so dated 27/5/2020, is yet not legally valid and no government concurrence was obtained acquired while passing the said order. Moreover, the adjustment of Srimati Beauty Deka as Hindi teacher of Polastol Kasamari High School was made against the post fallen vacant with effect from 30/4/2018, which proves that Srimati Deka was not rendering her service against any vacant post of Hindi teacher in the school. Therefore, the order number so and so dated 27/5/2020 of regularization or adjustment of service in respect of Srimati Beauty Deka as Hindi teacher of Polastol Kasamari High School under Nogao district is hereby recalled and cancelled. Further, the Inspector of Schools, Nogao, being the appointing authority in respect of assistant teacher, is hereby directed to take necessary steps to dispense of service of the Beauty Deka. Now, my lord, First, my lord, the post against which petitioner was transferred, my lord, that is still lying vacant, my lord. But her service has been regularized against another post, which has fallen vacant, with effect from 30/4/2018. So, my lord, this is not correct, my lord. And another aspect, my lord, the notice was issued regarding regularization of service of the petitioner, my lord. But here, my lord, not only, my lord, recall the regularization order, but also, my lord, on dispense with, thereby, my lord, cancel, terminated the service of the petitioner without affording proper opportunity of hearing, my lord. Before termination issued by, to issue, my lord, termination order by the government, my lord, to a government servant, my lord. They must follow some procedure, my lord. They must issue so-called notice specifically, my lord, with specific grounds, my lord. And we must have an opportunity to submit our reply, my lord. Thereafter, the authority may consider, my lord, to whether my service can be terminated or not. And moreover, my lord, I am one of the 82 Hindi teachers, my lord, who were appointed in, my lord, answer school by the government, my lord. And total 76 numbers of Hindi teachers have already been adjusted, my lord. And another two, my lord, teachers like me, my lord, they were also subsequently, my lord, adjusted, my lord, by dint of the, my lord, order passed by this honorable court. And they are also having noted, my lord. So, my lord, and further, my lord, this honorable court has disposed of the last order, my lord, whereby, my lord, petitioner's claim was rejected, my lord, only on the basis of
Notice may go,
regularization
your
order
lordship.
passed by this honorable court. So, my lord, if I am refrain from, my lord, continue from the service, my lord, it will, my lord, cause irreparable loss and injuries to me, my lord. And, my lord, there is no other Hindi teacher at present, my lord, since the year 2018 at that school, my lord. I am serving as Hindi teacher, only Hindi teacher, my lord, at the school. And that is reflected in working certificate, my lord, that is issued by the headmaster, Annexure 33, page 129.
Regularization order was issued when?
On 27/5/2020, my lord. That is, my lord,
Where?
my lord, page 103, my lord. 27 May 2020, my lord.
And this was issued during the pendency of the writ.
My lord,
This was issued
Pendency.
during the pendency of.
my lord, my lord. During pendency of the earlier writ petition, my lord, 543 of 2018, my lord. And, my lord,
Petition or
direct,
readable?
no, my lord, writ petition, my lord. During pendency of, my lord, writ petition, that is 543 of 2018, my lord. And, my lord, the director of secondary education filed the affidavit, my lord, stating that my post has, my service has already been regularized. And on that basis, my lord, this honorable court has disposed of that earlier writ petition, my lord. That is reflected in paragraph 12, my lord, of the order.
Yes, what is your submission?
Your lordship, notice may go at this stage, your lordship.
And regarding his interim period,
Your lordship, it will be considered on the next date, your lordship. Let the notice may go at this stage. Because he was submitting his part, your lordship, that the department may take a stand, your lordship. On the next date, your lordship, kindly notice may go at this stage.
Till then, my lord, the operation of annexure
No, your lordship.
31 may be stayed, my lord. Otherwise, my service will be discontinued, my lord.
short date may be given, your lordship, let the notice may go, your lordship, and his interim may be granted on the next.
Once my service will be discontinued, my lord, it will be difficult for me, my lord.
This speaking order has passed, your lordship, after revisiting that file, your lordship, and after carefully re-examine the documents.
But that is not in conformity with the my lord prevailing rules.
Short date may be given, your lordship, 82 persons were there, your lordship. Along with petitioner, the cases of 76 numbers of petitioner, another
Madam, you
person.
see, it's a order was contrary to the order. They passed by this court in the WPC number 5443 of 2018.
109, no?
During the pendency of the dread petition, the director has filed affidavit informing the court that her service has been regularized. And now suddenly she has been terminated from service, dispensed with service.
That is to
Short date may be given, your
5 years of
lordship,
my lord.
kindly notice may go at this stage.
But you can just learn it to something. He does learn it. Sending toxic product response he implemented it.
Instruction होते कि मैं
Secretary
speaking order pass with another.
Take the respondent number 1 and 2,
1, 2, and 3.
1, 2, and 3.
There is a private respondent,
Yes,
their headmaster, respondent number 4.
borrow for respondent number 5. Or 5. In this petition under Article 426 of the
PDF এটা মোক আজিয়ে দিব দেই soft copy
The
এটা
petitioner
phone number
has
টো দি দিম
challenged the order dated 30th May 2025.
Two orders, my lord.
22
22 8.
2025. And
Consequential order, my lord. And except 31,
31.
my lord.
And also the letter dated 30th May 2025, by which the service of the petitioner was dispensed with, by recalling her regularization order. Sir does learned counsel for the petitioner submits that the petitioner was appointed as indeed deserved by the managing committee of the school of the dancer Corbetti Girls High School under Northern District. Pursuant to resolution of the managing committee dated 21/7/1990. Thereafter, the government by letter number EED dot 567/91/113 dated 7/91 had created 500 numbers of Woodstock Indian Research Center centrally sponsored. And thereafter, the petitioner was appointed as inmate against senior grade teacher on ad hoc basis for a period of 4 months. The fixed pay at the rate of rupees 1,375 per month at Borgatti Girls High School, which was not provincialized at that time by the inspector of Mr. Plano by order dated 17/1995. Subsequently, one post out of 82 posts of ad hoc secondary ad hoc secondary school. Post for ad hoc secondary school was allowed at the consolidated basic pay at the rate of rupees 1,580 rupees per month without any financial benefit by government letter dated 36,000 was allotted to Borveti Girls High School and Seniority duty the present petitioner was adjusted against the said allotted post by officer dated 12/7. Hereafter, the petitioner was transferred to Polasco Customary High School. By order dated May 2006. 2006. And since her joining in the said school, the petitioner has not received her salary. Thereafter, the post of head teacher in Polasco Customary High School was advertised on 2013. And being aggrieved, the petitioner has referred one petition with WPC number 3779 from 2013. Challenging the said advertisement and claiming regularization of our service. But by order dated 1/8/2016, this court was pleased to dismiss the claim of the petition. Being aggrieved, the petitioner has referred one DWP WA number 19 of 2007.
Had order dated, my lord, 1/8/2016. The respondent number one was directed to.
All this stuff at the time of the and the said appeal was disposed of, directing the respondent authorities to release the salary of the petitioner on the principle of quantum merit. And also granted liberty to the petitioner to assail the communication dated 24/1/2007 in an appropriate proceeding before appropriate forum. Thereafter, the petitioner is referred one written something application number 544 of 18. And during the pendency of the aforementioned petition, the director Secretary Education has filed an affidavit stating that the service of the petitioner has been applied. Thereafter, this for side order dated 19/7/2023 has closed the disposed of the same petition. To pay regular salary to the petitioner in terms of the government order of the government dated 27/5/2020. And subsequently, a sum of rupees 6,47,650 as arrear salary was paid to the petitioner with effect from 1/7/2010 to 30/6/2013. And while the online proposal for releasing the first salary of the petitioner was home, then the government has found that the government has raised objection on issuance of regularization adjustment order in respect to the petitioner. By letter dated, by the office order dated 27/5/2020. Thereafter, the director, secondary education has passed the review order dated 22/8/2025. And consequent upon said order, the inspector of school logout by his letter dated 30/8/2025 has dispensed with the service of the petitioner. Mr. Das Learned Counsel for the petitioner submits that the impugned order dated 22/8/2025 and the letter dated 30/8/2025 was issued without giving adequate opportunity of being heard to the petitioner. And the same orders are passed contrary to the order of this court dated 19/7/2023, passed in WBC number 5W40 of 2018. And had the petitioner been given adequate opportunity of being heard, the petitioner would have furnished the relevant evidence and document before taking the decision of dispense with her service. And in such order, dated 22/8/2025 and also later dated 30/8/2025 are in contravention of the principle of necessary and necessary state person of the said order and the letter will dispute the of this. Per contra, is thus learning. Nothing counsel for the respondent number two submits that this is it only notice may be issued. Giving time to the respondent number it's take it time. Having heard the submission of parties provided that and also considering the fact that of the record is provided and obviously to respond for weeks.
Notice issue.
However, no formal notice is required to respond. What to pay and why in they are represented by their respective counsel. It's nothing counsel, however, it's very good set of the part. State upon respondent number 4 be taken by registered post with AD and also by legal person. Further, considering the submission of Mr. Das Learned Counsel for the petitioner and also considering the fact that the interim order dated 22/8/2025 and the communication dated 38/8/2025 was passed in contravention of the principle of natural justice and also in contravention of the order being passed by this court by order dated 9/2023 in publication number 5/14/2018. A prima case and also the balance of companions and irreparable loss is found in favor of the petitioner and according to the impugn order and the order dated 22/8/2025 and the communication dated stands state till returnable at list of reports.
Here this matter relates to non-payment of arrears salary lordship and similar benefit were extended to the other similarly situated persons also in terms of this honorable court's order. And background of the case is that lordship here in the year 1993-94, the state of Assam lordship undertaken a process of recruiting teachers lordship. And accordingly, the petitioners along with some other persons were appointed. And after for some years, lordship, some anomaly, some disputes arose, and thereafter the state of Assam constituted a one-man committee, namely lordship Manoharan Committee, who lordship inquired all the irregularities and categorized the appointments in three categories, lordship. First category, that is regular appointees, their appointments were not touched by the Manoharan Committee. Thereafter, lordship, one was termed as irregular appointee, and third category was illegal appointee. And they were also the irregular appointees were regularized from in the year 2000 to 2003. They were regularized, lordship, and the petitioner service were regularized in the same year, lordship. And the other persons, lordship, who were similarly situated, lordship, they were also denied that benefit of area salary. They approached the court, this honorable court, and their application was allowed. That your lordship will find page 53. And the state of Assam lordship thereafter filed one writ appeal against that order, which was lordship withdrawn with liberty to file a review application before this honorable court. And that liberty was granted, and thereafter they filed review application. So lordship may kindly see that review application order. Elaborately, every fact is given there, page 56. Lordship may kindly see page 60, that is the background of the case, similar facts which I have stated before your lordship. Page 60, your lordship will get the background of the case. So that three categories were there that your lordship will get: regular, legal, valid appointees, irregular appointees, or illegal appointees. And that discussion starts from paragraph 11, page 61.
So by this order, the state respondents were directed to pay your arrears like.
Other petitioners who are similarly situated. Lord. And thereafter, lordship,
Notice may go at this stage, notice may go, I'll bring instruction and let us file our affidavit, my lord.
my whole case is that when some of the accused person, some of the similarly situated persons are granted that benefit, the same benefit cannot be denied to the present petitioners, lordship. And in that I have relied on one Supreme Court judgment, okay, that page 85, even though that some person do not approach the court.
So, Bora,
My lord.
you examine the matter if the present petitioners are similarly situated with the petitioners of that review petition.
My lord.
You cannot really
My lord. Lordship want to dispose of this petition directing the authority to verify.
why should keep the matter pending.
My lord, my
The
lord.
next day, another advocate will appear.
My lord,
and he
my
will
lord,
state
my
that the
lord, my lord. I have no objection.
instructions are not available.
My lord. Only thing is that let them file a detailed representation before the authority concerned. Yes,
One representation has already been filed on.
that is there, that is there, annexure A, my lord, yes. That is page,
Annexure A, yes.
page 66, my lord, that is of 2024, my lord.
Yes, December 26, 24.
But can you ascertain from the office of the commissioner whether they have received this annexure A or not?
My lord,
They have
here,
put
my
their
lord,
initial.
some initial is display, my lord.
Page 66 down left side. And acknowledgement receive also we have enclosed. Page-
Let the authority decide, my lord, on
We
this
can submit
representation.
a press representation also, that will do.
Disposing.
Oblige.
Oblige, Lord. 17 also same. Lord. Here only thing is that he earlier filed one application before this honorable court. This honorable court directed to file a representation before the authorities. They rejected my case, Lordship. And subsequently this similar superior person's order came up. Oblige.
Oblige.
May it please, your lord. Matter relates to compassionate appointment law. Petitioner approached earlier before this court, lordship. Thereafter, lordship, DLC recommended the petitioner, lordship. And after recommendation, lordship, the matter forwarded to the SLC. Now matter is pending before SLC for consideration. In the meantime, office memorandum has come, lordship. So my
Lordship, page 33. Page 33, your lordship. Proposal was placed before the DLC and it was seen that the applicant was 17 years, 11 months, 7 days at the time of submission of original application. Despite not being 18 years of age at the time of submission of application, the proposal of the applicant was considered for appointment on compassionate ground for grade 3 post in any other department as a special case.
Yes.
So that particular DLC took place at which date? That has not been referred to in that DLC decision at page 33.
No, it is mentioned at top of the resolution held on 38/8/2024.
No, lordship, that language, your lordship. Proposal was placed before DLC and because the father of the petitioner died in the year 2004. So definitely thereafter the petitioner submitted the application. So the language says that at that time she was or he was 17 years, 11 months, 7 days.
Let's kindly peruse the earlier.
Despite not being 18 years of age at the time of submission of the proposal or application was considered for appointment on for grade 3 post in any other department as a special case. Order to quit.
Yes, 20.
So now place the matter before the SLK.
Yes,
lordship, that page 28, your lordship. Page 28. The OM upon which the petitioner is relying is, your lordship. That top principle, page 28.
Paragraph number.
That first para only, page 28, first para. So, these two submissions, if your lordship report it,
My case is similar with item number 7, Lordship.
because
I think.
2004, now after
Today,
21 years,
No, the matter came before the DLC for consideration only on 38/8/2020.
lordship, the petitioner's father, near one got deceased. After definitely within 1 year span of time, he or she has to submit the application. This is the rule that has been provided in that 2015 OM. Yes.
The DLC has considered the same.
Yes.
They
No,
recommended her name.
but that language is not, because after the DLC cannot take up the matter. She has submitted the year in the application in the 2004. DLC cannot take up the matter after 20, after a span of that much of years.
We cannot examine that issue now. That is not the issue before the court.
Yes.
Lordship, that page 33, your lordship. If I'm not wrong, what I want to bring the notice of this honorable court is that that's 17 years, 11 months, 7 days. So definitely the language says that at that time it was placed. And though the petitioner was 70, not eligible, but her case was placed as an despite not being 18 years of age at the time of submission of application. The proposal of the application was considered for appointment on compensation ground for grade 3 post in any other department as a special case. So at that time, one DLC took place. What I getting from this language is here.
No, this resolution came to be passed on 38/8/2024,
Yes.
1 year back.
Yes, Lordship.
Was considered for appointment on compensation ground.
Let the matter be placed before SL.
That can be. Lordship may record my observation. That's my humble submission.
Obliged, Lordship.
Number 42.
Happy Lordship. On the last occasion, I seek permission to file an additional affidavit to bring on record the annexer and Lordship. It is in the page 44, Lordship. Notification. In the petitioner, Lordship.
So what was your prayer?
My prayer was to consider my seniority, Lordship. Nothing. Only to consider my seniority. If any seniority list is prepared, Lordship, my past 12 years of experience in that school, Lordship, may be considered.
So Sarma?
But still, my lord, headmaster is not retiring from the school.
He will retire in 2 months' time, Lordship.
Already retired.
No, 2 months' time.
And then,
November.
so his apprehension is that, his name will be not appeared in the seniority list, my lord.
That's my apprehension, Lordship. That's why.
We filed this petition only for his apprehension, my lord.
So, Mr. Sarma, let us dispose of this petition by directing the authority to consider his seniority in terms of this notification.
Yes.
Annexer N.
Yes.
That would be lot.
Yes, yes. Important.
Or next start.
UP चलिए lot.
Or next council for the. Sir. You sort of learn it.
For respondent number 2, 3, and 4, my lord.
Secretary at the. Secretary. Part. Number 2, 8, 4, and right up.
I am for respondent number 1.
Number 1. Article 26 of the. Private direct. So, the senior seniority list. Of the teachers of portal, the knowing of higher secondary. Higher secondary. So they have learned a computer the petitioner subject. The petitioner was appointed as science teacher in portal of the high school. Cases is with text. And he joined on the same day. And during his service as conflictual research, he had completed BA degree in College of Education Honolulu in the year 2018 with the Department of Doctor.
2016.
Here, the service of the petitioner was regularized. While office member income between
2016.
number PMA 30 from 2010 to party. And subsequently, the petitioner obtained MA degree from Krishnakanto and Lake State Open University in education in the year of Thereafter, in the year 2020, the petitioner appeared in the test where he had qualified. Qualified by scoring 116 out of 200 marks. Then the petitioner applied for postgraduate exams. As he fulfilled the criteria as given in the advertisement according to the list of candidates under system MBBS category of graduate teacher for the district of Moreno in serial number 3. In the final elections of graduate research second page. Thereafter, by order dated certified by into the graduates. Ahurigan higher secondary and according by the join the state of 65. Thereafter, the petitioner was initially transferred from Florida Higher Secondary School to Florida Higher Secondary School, which was his earlier school. By order dated 7/2020. Person to six level committee for transfer search. As per Assam, as per the provision of Assam elementary and secondary school research. Regulations of posting and transfer and so we have further songs that and the apprehension of the petitioner that is service of the school since the year 2010, 2020 may not be counted for determining its seniority. And therefore, the petitioner approached this court by filing the present petition, seeking the relief as appropriate. Normal learned nothing counting for the respondent of her. However, some extent, the postage yet to be taken. And he had no objection in the event of disposing of this petition in terms of the notification issued by the government. And in 2025, wherein it is provided that where it is provided for counting the seniority. XR and
Annexure and lordship is only
point number one.
point number one, lordship.
Point number one.
Point number one.
Where provided that past service of the teacher shall be counted for the purpose of granting transfer under the teacher transfer and loans. Having heard the submission of burning of both the parties. And also, there is the notification petition 21/8/2025 by the Secretary Department of the basic facts here in this case. Here in this petition is not in dispute. The petitioner was appointed as science graduate teacher. Science teacher in
Graduate.
Portal Togoika Fire. And he had acquired the BA degree from the Togoika Education Morrigan the year 2000 and something. By the office memorandum dated 3/8/2016 in services decorated. Subsequently, he also acquired MA degree in education from KK and the State Open University. And he applied for the post of graduate teacher science. And there was selected and appointed as graduate teacher in Laurigan Higher Secondary School by the order dated 5/5. And Subsequently, the petitioner was transferred from Bahurigat Higher Secondary to Portal Lodhia High School by 2017. Pursuant to the resolution of the district level committee transfer and posting of officers. As per provision of Assam Elementary and Secondary. February is part 20. It also appears from parallel of the notification dated 21.
21/8,
21 8
21/8,
2020.
2025.
21 8 2025.
Five.
Then all service of the teacher shall be counted for the purpose of the teacher as per Act and rules. And also P of the said notification also indicates that the teacher's sector is under the equipment guide shall become headmaster or principal high secondary school. Instruct secondary school, provided he instructs the police requisite norms as prescribed under the Assam Secondary with Provincialization School. Service Rule 2018 as amended. And the Assam Secondary Education Government School Service Rule 2020 as amended. After the given facts and circumstances, I am also taking note of the subparty of both the parties. By directing the respondent authority on the past service of the petition. Since 2010, from 2010 to 2020. While preparing seniority list, officers of the school from of the portal Doloidao of portal Doloidao higher secondary. Higher secondary. Especially in terms of the notification date. But they have to bear their own control.
Madam, direction may be given to the petitioner to furnish the certified copy along with a representation or a letter to the inspector of a school so that the order come to the knowledge of the authority.
The petitioner shall obtain a certificate of order. Yes, sir. 1 week from
Applies also.
May I please? The petitioner, my lord, this case is, my lord, listed earlier on the 2nd of this month, my lord. On that day, we took an adjournment because the second counseling for the for the MBBS course has been stalled, my lord. And my lord, after that, the petitioner has submitted a representation by post, which was earlier refused by the DME Assam to accept by hand. And
what happened, my lord? The petitioner has passed the NEET UG examination, page number 23 of the writ petition, where your lordship will find he has obtained 429 marks. In the obvious in the NEET examination, my lord. The petitioner belongs to, my lord, OBC non-creamier category, my lord. And your lordship will find in page number 32, annexure 12, the candidates having 407 marks against OBC non-creamier certificate quota, my lord, they have been admitted, allotted the seats and admitted, my lord. The DME Assam, my lord, while doing the first round of counseling, my lord, they have issued one notification on 4th of July, my lord, on 4th of July, whereby they have permitted, they have invited applications for converting the category, those who are, my lord, belonging to other category, and they appeared in the NEET UG examination as general category or whatever, my lord. They have been asked to, my lord, apply and for their conversion, my lord. It was at page 26. The petitioner, my lord, as he could not, my lord, obtain the NCL certificate, my lord, on that particular time, my lord, he could not apply for the first round of counseling. And now, my lord, he has procured his NCL certificate at page 30 and 31, my lord. And applied through.
Mr. Prudence,
Yes, lordship.
whether the rule provides for ending of the category.
The rule, my lord.
To OBC NCL.
That they have issued the notification at page 26, my lord, indicates that there is some, they have the power to 26. This is the notification, my lord. They have issued prior to convening first round of admission, my lord, whereby they permitted for change of quota, my lord, or category, and those who are those who have procured the certificate later on, my lord, they have been allowed, my lord, in the first round of counseling. And accordingly, at page number 38, in respect of one similarly candidate, my lord, the DME Assam has issued the order also, corrigendum. Now what happened, my lord? In the second round of counseling, initially there were only 4 seats for the, my lord, MBBS OBC NCL category. But now they have increased the post seats, my lord, around 56. I have given the chart in along with the.
So you could not able to submit the document by 11th of July.
Yes. I procured it after completion of the first round of counseling on 27th. On 27th of August, my lord. Page number 31. And thereafter he has.
And the authority considering.
Yeah, my lord, during the first round of counseling, they have provided the option for, my lord, changing the category. And during the second round of counseling, they have increased the number of seats. Had there been no increase in the number of seats, my lord, then I might not have the case, my lord. Yes, because they have altered the number of seats right now after postponing the second round of counseling, my lord. Therefore, they have to go for the parity.
Yes, my lord. My lord, that annexure 8, page 26, my lord, that educational notice. So it clearly states, my lord, candidates who want to.
11th of July.
Yes, my lord. So after that, it is not permissible because after issuance of the educational notice, whoever applied, my lord, and subsequently, as he has referred to page 38, my lord, some has changed their category, my lord. And after that, my lord, the merit list has been published and first round of counseling is over, first round of admission is over, my lord. Now at this stage, it is not permissible, my lord.
No, he submits that the number of posts has been.
No, number of posts has been increased. Maybe that is in view of some other circumstances, but this cannot be allowed, my lord. There will be several applications, my lord, for change of the category. Because on earlier occasion also, on earlier years also, my lord, after the cutoff date, my lord, no category can be changed. Because he was not eligible, my lord, as per that category on the date of publication of this notification. So he's not eligible, my lord. And
Subsequently, it has been relaxed by this notification.
Yes, Lord.
14th July of 2020.
yes, my lord, 4th July. So that was the cutoff date. On the date who were eligible in terms of this notification, they applied, they have been allowed. So after that, because here in the specifically stated, my lord, can clause 1, candidates who want to change their category can now apply in a prescribed format, which will be available in the official website so and so from 5th July 2025, along with the supporting documents to the office of the undersigned on or before 11 July 2025 during office hours by hand. No further application will be considered by this office after the last date of submission. So after the last date of submission, my lord, the final merit list was published. First round of counseling was done, first round of
Right, but in respect of second round of
Counseling.
yeah,
category cannot be changed now, my lord. Because
They-
there will be other candidates also, and there are several other applications, my lord. So now it cannot be changed. If due to some circumstances, have been enhanced, my lord. So for those seats, my lord, the persons who are,
Mr. Bora,
yes, my lord.
this notification was to the 4th of July.
4th of September.
2025.
Yes, my lord.
So before or after the first round of counseling?
Yes. Before first round of counseling.
Before.
Yes, my lord. After this notification, my lord, because my lord, on the bottom of the notification, your lordship will find the final merit list shall be published after incorporating all valid claims in due course of time in the official website. Down below, my lord, your lordship will find in bold letters, my lord. So after this notification, after entertaining any application in terms of this notice, my lord, the final merit has been published, final merit list. And on the basis of that merit list, my lord, first counseling and first phase of admission has been done, my lord. So now the midway, he cannot be allowed, my lord. Not only he, my lord, others also, my lord, maybe that there are some other candidates also, but it cannot be allowed now.
My lord, to counter my learned friends, my lord, when suppose an advertisement is going on in the process, my lord, 10 posts have been advertised. For the 10 posts, you have to taken the merit list. Now you are increasing to 15 posts and you are not allowing the other candidates to participate. That is discriminatory, my lord. That is why you are, once you increase the seats, once you increase the seats, my lord, you have to give the opportunities, equal opportunities to others. Because you have given in the first round of counseling, you have given. Had you not been given, that a different thing. In the first round of you have given for
Mr. Bora, you have not filed affidavit yet.
No,
it's
my
a
lord.
motion case, my
In
lord.
fact, no, notice has
It's
not
an
been issued till date.
my lord.
No, Mr. Bora, offline inspection, can the authority consider?
No, they cannot, on last occasion, I produced one instruction,
Yes,
my lord.
ma'am.
They cannot, my lord. They specifically stated.
My
Because
lord.
they are because there is a guideline from National Medical Commission also, my lord. They cannot change now, my lord. After the first round of counseling, after first admission, no one can be allowed, my lord. I have obtained specific instruction from the Director of Medical Education. On last occasion, I produced the instruction, my lord.
My lord, as per rule 14 of, I've given the rule also, my lord. As per rule 14, my lord, every candidate has got the right to appeal.
He has not the right to file application also, my lord, after this 4 July notification notice, my lord, educational notice.
They have accepted my application, my lord, at page 34 in online system as OBC NCL category. If the system permitted, my lord, had there been any objection, my lord, that system could not have permitted.
When this application was submitted?
Before the cutoff time, my lord. It was submitted,
No, before cutoff time, there is no problem. After cutoff time, after cutoff date.
not, it is before cutoff date, the second round of second round of counseling, my lord. Earlier, it was on 29/8, page number 37, date is there, my lord. 29/8/2025, it was accepted. They might have rejected my application, then I could have the right to appeal, because the statutory provision provides that every candidate has the right to appeal if the selection board rejects the application. They are refusing to accept even the hard copy. I have to send it by registered post then.
No, why should they accept it? They have already notified the cutoff date.
My lord, cutoff date in respect of first round of,
Oh my,
So,
what?
okay, so you see, if we allow this application, then we have to open the bucket.
Not only floodgate, the entire merit list, my lord. The first round of counseling, everything has to be reversed, my lord. The process is on the way, my lord. It has been finalized, my lord. So first round counseling, second round
So
counseling.
for
Yes,
let
my
them
lord.
dispose of my representation by rejecting that prayer, my lord. Then the
Oh,
then at least the petitioner have the right to appeal.
short affidavit, including the guideline
yes, my lord. I may file it, my lord.
on on Wednesday.
Wednesday will not be possible because, my lord, all officials are busy with the admission process, my lord, process. So I will have to send
This
the,
matter also relates to admission.
yes, my lord. No, my lord, by Friday, my lord.
Counseling will be over, my lord, by 11th. Before that,
Before that day, you file the affidavit. Third is a proof so third and fourth court of degree for Lord advocate for good number provide for sort of thinking of getting the guidelines of
National Medical Commission.
National Medical Commission. Please the method on.
as well as, my lord,
My lord, second round of counseling is from 10 to 19 September. So, your lordship,
No, my
because
lord.
the Friday is a holiday. So on 15, my lord.
19th will be, my lord, only for the date of declaration of the result. And the 11th is, my lord, for counseling, my lord. I've given the notification. Second.
Yes, my lord.
Pardon?
Thursday, my lord, on this. My lord, I have got the 22nd, because the latest notification, the second round of counseling is from 10 to 19. So, my lord, on
I've given the
15th, my
notification.
lord. 15th, my lord.
So for
Yes, my
I
lord.
appreciate that before starting the second round of counseling,
Before starting, because it will start from 10 September. It will start from 10 September.
by 11 you file it.
Yes, my lord, I will try, my lord.
As well as my annexing the, my lord, the guideline which issued by the government, which provides the changing of the category, because they have issued the notification on 4th of July, my lord, regarding the change of category. That must be basing on some guidelines, my lord. That notification guideline may be annexed, my lord.
No, that is whatever we will file.
Because the
we will
director
file.
cannot,
He
my lord,
cannot say.
director cannot suo moto issue such guidelines, my lord, for change of category.
If
Without
he
having.
cannot issue, then why he is claiming, my lord?
My lord, if that is on the basis of guideline, my lord, it has to be for every counseling, my lord. It's not for a particular counseling. That has to be
Yes, my lord.
included.
In his affidavit.
Obliged.
Obliged.
Admission, 19.
My lord, matter may be taken at 2 p.m. lordship.
Why?
Lordship, my senior Mr. Alarm is like in court number 18 lordship. Obliged.
May I please, Your Lordship? Matter pertains to the pension of the petitioner, my lord, and
I'm praying for 10 days time to instruction, I'm awaiting instruction. The updated instruction.
I only prayer is that, my lord, Your Lordship, matter is parted, my lord, and
By order dated 6/3/2025, it has been indicated that no further time will be granted.
In fact, my lord, the last to last order, Your Lordship will see, my lord, we have submitted a letter from the secretary, my lord. This honorable court granted us to take the updated instruction.
Pay cost. You will allow them. Right.
Just a week.
I have a flood account. Also heard Mr. Kosik. Elementary education department. Mr. Kosik submits that. He may be granted further 10 days time to receive instruction. But it appears from the order dated 6/8/2025 that no further time will be granted to respondent to file their affidavit. How 10 days time is granted subject to payment of a post of rupees 10,000, which shall be deposited before the in the advocates welfare fund of the Guwahati High Court.
Well, there's the last.
Your Lordship,
Lordship will give his last chance, my lord. But subject to, my lord, if not, my lord.
my lord,
Exactly.
my prayer is that Lordship may kindly fix a date, my lord. My lord, since petitioner is suffering, my lord, he is bedridden condition. Obliged.
Your Lordship, I am for respondent number 4, Your Lordship.
May I please? In this case, my lord, the impugned order at page 31 has been issued by the DC at the instruction of DC, my lord. However, 1 day pay salary has been deducted by the authorities, my lord, of the petitioner. Let me read, my lord, there are 4, my lord. The undersigned visited 118 number Irangmara LP school and would like to provide a report on the observation made during the inspection. The school, as per UDICE records, has an enrollment of 274 students and a total of 10 teachers. However, at the time of inspection by BP Pathak, head teacher, and such assistant teacher were found present, while remaining 8 teachers were absent. Midday meal was observed to be cooked according to MDM menu chart. However, it was also noted that the head teacher had suspended the school before the scheduled timings. In the light of these observations, it is recommended that a show cause notice be issued to the head teacher for premature disclosure. For closure of the school. Similarly, show cause notices should be extended to all 8 teachers who were absent during the school hours, accompanied by a 1 day salary cut for each teacher. Thereafter, my lord, a show cause notice has been issued to the teacher concerned and petitioner, my lord, and he has replied, my lord. Page number 34 is the reply. And that day, that is 15 to 2024. Firstly, in the earlier morning, at the time of attendance, the students and their parents requested not to serve MDM as they all. Yes, sir.
Who is referring to elementary education department?
They have not filed in response, my lord.
Elementary. 22.
They have taken times on earlier occasions.
We will grant us 3 weeks time to file our application.
Affidavit আহিব জানো?
How many adjournments you have taken?
I think one, my lord.
Pardon?
One,
Have you gone to the record?
it's for my record, my lord.
You have been asked to file affidavit in opposition within 4 weeks by the order dated 11/12/2024. Thereafter, on 2 occasions, the matter was listed. Same pair.
My lord. Two weeks time, my lord. Lordship will give us 2 weeks time. I'll ensure, my lord.
Whether you have informed the respondent about pendency of this petition?
But our system, my lord, immediately when the extra copies are sent, my lord, it is sent to the department, my lord.
Then why the instructions are not coming? Affidavits
But
are not
sometimes, my
filed?
lord, the instructions are not coming from the district also, my lord, where districts are involved, my lord.
Whether this matter relates to the district?
Yes, my lord, district.
Yes.
It's a district commissioner order passed by the district commissioner, Silchar, my lord.
There must be a system to obtain a instruction or the federal government.
My lord, yes. Basically, my lord, district commissioner doesn't come within the, my lord, the education department, my lord. It's a deputy commissioner.
And this impugn order is issued without any jurisdiction also.
Yes, madam, you were representing the deputy commissioner?
Yes, Your
So why the instructions are not made available?
We have communicated, Your Lordship, not
When?
yet. We have communicated on 13/6.
13/6.
Yes, Your Lordship.
No, thereafter no response has been received.
Yes.
Then let the deputy commissioner if it's present in the court.
One chance may be given, Your Lordship.
You see, already 2 sons have been given. Partners are put so learn from product. All partners are big learn something from the product content partners. That is open for the just on that number. 4.
3, Your Lordship.
3. The deputy commissioner concerns. The posting submits that. The matter relates to Kasar district. Then concern information have not been received from the district commissioner Kasar Silchar. And therefore the affidavit cannot be filed. Spoken learned counsel appearing, standing counsel appearing for the respondent number 6 submits that he has communicated the matter to the district commissioner Silchar. When you have communicated
13/6/2024.
13/6/2020,
4, Your Lordship.
2024. And since then, no information has been received. However, the Spoken submits that he may be granted another chance. It is accordingly allowed. If the information and the affidavit in opposition is not being made available on next day, the court will consider directing the deputy commissioner Kasar Silchar to remain personally present before this court. Place the matter on
29, my lord. Obligation.
My lord, this matter may be taken at 2 p.m. also.
25/26.
Well, in this case, we have received instruction, my lord, may run 3 weeks time to file affidavit.
Then, my lord, kindly fix the matter, my lord. Let they have been received the instruction and they want to find the reply, my lord. Kindly fix the matter. Otherwise,
You have not filed your.
No, my lord. We're going to file, my lord, 3 weeks time may be granted.
Pardon, sir.
arrest.
curriculum permanent on the product. Yes, it's the chief and effects on that we will bring on record us in by filing an affidavit in best for graphic hard is the record allow the matter of fact.
Wait, kindly fix the matter, man. Kindly.
24th October.
Otherwise,
May I please, Lordship? This is the sixth round of litigation, my lord. Continuous cause of action is going on and the petitioners has been subjected to harassment by the department. Instead of 2 times mandamus has been issued by this honorable court, my lord. The petitioner, my lord, approached this honorable court. I take your lordship to the page number 21. This is the type copy of the seniority list of the petitioner, my lord. It was prepared on 2023, wherein petitioner is shown as number 1, my lord, and his date of joining is 31/3/1992. And respondent number 4, he is junior to petitioner, my lord. His date of joining is 2009. Now what happened, my lord? The petitioner earlier challenged this challenged, my lord, that annexure 2, page 24 before this honorable court, order dated 30th March 2023, whereby another junior incumbent, my lord, was allowed to hold the charge of principal of the school, depriving the petitioner. And thereafter, my lord, this honorable court, by order dated 18/12/2023, page number 27, you will find, has allowed this writ petition directing the page number 33, paragraph 10, directing the director of secondary education to allow the petitioner to hold the charge of principal of the school, my lord. Mandamus is issued, page number 31, paragraph 10. What happened thereafter, my lord? The director of secondary education, in violation of the direction of this honorable court, has issued another impugned order. Page 33, annexure 4, my lord. It was issued on 7/4/2024, whereby director has directed the inspector of schools to conduct departmental proceedings on account of not having the NOC for higher qualification. Yes, Lordship.
So, Sona,
Yes.
so by the order dated 10/4/2025, you can say that whether the inspector of school has the competence to cancel the ACR.
Yeah.
Whether
Your lordship has taken the item WBC number 2003, I think.
28.
Yeah, 2003 at 28. I'm submitting from my lord. I'm submitting actually from item number 29. That is why it's not telling, my lord.
Yes.
No problem. No, this is the same issue is some different. Item 29 is with regard to the head principal in charge, and 28 with regard to the SER of the same person.
My lord, instruction has not yet come from the inspector of school, my lord. So sometime may be granted.
It is repeated. This is
No, it is a matter of 25, my lord. 2025.
It is not a matter of 25 months running from 23, my lord, and it's a 6th round of litigation. In fact, there is no requirement of affidavit at all. Everything is admitted on record. And I am submitting on the basis of their documents only.
Sometime may be granted so that I can take the instruction from the department.
Does it come on Friday then, my lord? Let my friend take an
Friday of the
next week and date, my lord. too late otherwise, because the petitioner is, my lord, deprived of his legitimate right in spite of this direction of this honorable court. They are taking this and that.
Respect of
Legitimate right, my lord, to hold
in
the
respect of-
post of
In-charge.
in-charge principal. Earlier occasion it was given on returnable date, my lord, interim consideration will be there. So, my lord, at 2 p.m. your lordship may be further hearing for interim direction at least, my lord, if they take time. Impugned order may be suspended then.
On my lord, he is now in 58 years, my lord.
But that I will submit, my lord, that I will that I will submit.
So, my lord, let the instruction come, my lord.
Then
Next
of-
Monday.
then of, coming week.
Monday,
Monday, I will be not here, my lord.
Wednesday.
Wednesday.
7th.
Or sir, so correct. You sort of are next. The coaching you were.
No, I'm not there.
Sir. Sort of submit that. Interim order is operating.
In respect of, my lord, item number 28, my lord. Into 29, there is no interim.
Sort of submits that though he was directed to obtain necessary funds of education. I ordered dated 10/4/2025 as to whether the inspector of school has the authority to cancel the ACR of the pensioner. The said piece of information is not made available to him and it tries to fix the matter the next week. That can be allowed to fix the matter on Wednesday. And in respect of 28, I can 29.
29 also, my lord.
Same, my lord.
Then
Both will
Wednesday, yes.
come on Wednesday.
Wednesday.
My lord, item 21. My lord, I've received the instruction just now, my lord. No, at 2 o'clock, my lord, I'll place the instruction. Lordship has imposed a cost, my lord. I've just received the instruction. Then on 6th of September, it was sent to the ARTPS department, my lord, for views, my lord, by the Department of School Education
Okay, at 2 p.m.
at 2 p.m.
Item from Itanagar bench for delivery of judgment. Item number 1, LFP 1 of 2024.
All the three appeals dismissed.
Deeply obliged.
Grateful, ma'am. Pending matters, item fixed at 2 p.m. Item number 44 for orders.
Wait, also. Well, I have gone through the compliance report submitted by the council for the condemners, my lord. Here they have granted the benefit to the petitioner with effect from 1/10/2014. 1/10/2014, and the direction was, my lord, will kindly peruse the direction at page, that's from page 21. Page 21, paragraph 20. In the light of the above, the court is of the view that matter is required to be remanded back for fresh consideration of the case of the petitioner. For promotion to chief engineer by holding review DPC, the petitioner's case is required to be considered as of 2008, 2009, when his juniors were promoted to the rank of chief engineer. Direction was to consider his case with effect from 2008, 2009, and the consideration has been made with effect from 1/10/2014. So, my lord, this cannot be the compliance of the announced court's order. Let this compliance report be
bring on record, my lord, by way of filing an affidavit by the respondents, my lord, I will reply, madam.
Yeah. Sorry.
I will file an affidavit also clarifying the entire aspect of the matter. I will enclose a copy of this particular communication.
Have you noted this observation made by this court in paragraph number 20?
Paragraph 20, my lord.
No, that I've seen, Lordship, but this particular aspect of the matter, I have to obtain necessary instruction from the contemnants. So I will get the instruction, I'll file my affidavit explaining the entire aspect of the matter, pursuant to which this communication has been set. So after 4 weeks, this matter will be taken up. So in the meantime, since the order has been passed, I will file an affidavit with regard to that. After vacation, this matter will be taken up.
Third is sir, I is here, learned counsel for the. Then. Sir, as each of you learned. Respondent number 3. On the other day, Mr. Soturi has produced a letter dated 4th of September 2025. Issued by the Assistant Administrative Officer in search of the respondent permit. It submitted that the order of this court has been complied with. A copy of the said letter dated 4th of September 2025 was furnished to the learned counsel for the petitioner. Today, Mr. I.S. Soikia, learned counsel for the petitioner, submits that the petitioner has been given the benefit from the date from the year 2014.
My lord. 1/10/2014.
1/10/2014, but the direction of this court in paragraph
20.
20 of the judgment dated
12/8/2015.
2015 was that the petitioner's case was required to be considered as of 2008-2009 when his junior were promoted to the rank of citizen. And as such, the order of this court has not been fully complied with. Then he submits that the council, learned counsel for the contemptor may be directed to bring on record the letter dated 4th September 2025 by filing an affidavit. And thereafter he will respond to the same affidavit. Accordingly, taking note of the submission of learned counsel from the parties, it's provided that Mr. Soturi shall bring on record the letter dated 4th of September 2025 by filing an additional affidavit. By filing an affidavit. By filing an affidavit. Let's list the matter immediately after the opening of the meeting. On
Obliged, Lordship.
My lord, if possible, my lord, can it be on, my lord, 22nd, my lord? October.
okay.
Obliged, my lord.
Number 24.
Eight lords, my lord. Here, my lord, this Imam is mother, my lord, had to come to this court, my lord, register organization, seeking the direction. Your lordship kindly see the prayer that there are 2-3 groups fighting, my lord, on the grammar of Manipuri and phonetics, for which the textbook corporation could not publish any textbooks, my lord, for the children under the 2009 Act, Compulsory Education Act. And last 2 years, they lost the session. Now is the third year. There is some urgency. Now let the leaders fight. But our simple guess is let the government and the SCRT call everybody, finalize the issue of grammar and phonetics, and allow the publication of the textbooks so that the children and their guardian do not suffer. That is the prayer. ABDB after ABDB has been coming, my lord. What is the objection in referring the matter to the government? It is interest of the children and the guardians who are suffering. Why they are putting so much hurdle? Now, SCRT ABDB will also see. SCRT says they have not countered anything against us. Says in the meeting it was called, but one of the parties was mistakenly left out, my lord, and that party could not participate. So let all the party be invited under the order of the government, and let the matter of textbook be finalized so that the children do not suffer. Who have the right to study up to class 7 in their own mother tongue. It's a compulsory education. We have to kindly come to parents now. So both the parties, madam, two parties have submitted two different grammars. Now, which one to follow? The respondent side, except respondent 5. 6, 7 they have submitted another grammar, and one group has submitted. Respondent 5 has submitted another group, another grammar. So SCRT is also confused. We are also confused. Our simple prayer, let the committee be constituted by the under the aegis of the government and the SCRT, and decide the matter once for all, and the language followed is Indo-Aryan language. You will also kindly come to prayer page 18.
Yes.
Yes, may I please your lordship. My lord, your lordship will find the matter is pending before the government, my lord. The whatever the issue, my lord, the senior my lord counsel has said, my honorable senior counsel has said, your lordship will find the affidavit of the SCRT, my lord. Then I will come to my affidavit.
Yes, that is there.
Affidavit of the SCRT, my lord, at page 85. Para 6. In a 85. May I read, ma'am? Para 6.
Yes.
Yes. With regard to the statements made in paragraph 6 and 7 of the writ petition, the deponent humbly begs to submit that different organizations representing Vishnupriya Manipuri community have come to SCRT Assam with different demands in respect of material development. Because of lack of intermingling among the organizations representing Vishnupriya Manipuri community, SCRT Assam has adversely affected in development of teaching learning materials of Vishnupriya Manipuri language. SCRT Assam has received a demand from Nikhil Vishnupriya Manipuri Mahasabha. I am Mahasabha. Why from this Mahasabha has come? This is another Mahasabha. I am representing respondent number 7. I am Mahasabha. Another Mahasabha has come, forwarded by the Honorable Minister of Education Assam, to withdraw all the manuscript of material submitted by Nikhil Vishnupriya Manipuri Sahitya Parishad, a wing of Mahasabha. This Sahitya, this is respondent number 6, a wing of Mahasabha. In view of conflict between the different organization representing Vishnupriya Manipuri community, and they have approached SCRT Assam and government with their demands. The undersigned communicated to the government by letter number so and so dated 19/5/23, requesting to take necessary action. So matter is pending before them, only for them. Their allied organization.
We are not at all in the same, my lord.
Their, yes, their allied organization have gone there, my lord.
Mr. Sharma, please sit down.
Yeah, yes, my lord. Their organization have taken the, my lord, signature of this education minister and come to the SCRT office, says that whatever the manuscript my wing, that is response number 6 has submitted, not to be accepted. Who are they? They have prayed, they're not to be accepted. For this, my lord, the matter is pending. Now, your lordship may kind of come to my affidavit now.
Mr. Sinha,
Yes.
now let the government take it.
Yes,
over.
government may take decision, my lord. This is not the community, my lord. Let the government take decision. They have gone to the government. Now, whether now the two literal groups have submitted the textbooks for acceptance, this publication or whatever the SCRT accept. Which one? Both of one. Now, two groups. There is one is Vishnupriya Manipuri Sahitya Sabha and another is Vishnupriya Manipuri Sahitya Parishad. Now, they have gone again us, my lord. Now, my lord, your lordship will.
No, Mr. Sinha,
Yes.
the pair is for directing the
Yes, here, my lord.
director SCRT to constitute a committee,
Now,
commission
Of-
of linguistic into urgent.
Yes.
Resolving the issue of correct.
that is the
number
issue, my lord. Issue did not discuss, issue did not raise before.
of publication.
SCRT did not get any issue, my lord. They are accepting. It is them, they are making it, my lord. Where is the grammatical contrast? SCRT never say, in their affidavit, it did not say there is a grammatical error or grammatical contrast. It is this organization, my lord.
They interview.
Yes, this or their writ petition says that, my lord. That there is a grammatical contrast. Let them show any order from the respondent, the SCRT, that yes, there is a grammatical contrast.
Anybody from SCRT?
Yes, SCRT. Nothing is in there is no grammatical contrast.
For SCRT council, Mr. Bijugo is on another court, my lord.
Who?
My lord, may I take, may I read my lord, para number 6, my lord. Again, my lord, because of lack of, my lord, the line starts from, my lord, because of,
Their affidavit.
because this is our affidavit, my lord. My lord, because of lack of intermingling among the organizations representing Vishnupriya Manipuri community, my lord. SCRT Assam has been adversely affected in development of teaching learning materials of Vishnupriya Manipuri language SCRT, my lord. I want to point out this line, my lord.
Hmm.
It is us, my lord, who has been adversely affected, my lord. And my lord, may I take my lord, may kindly peruse annexure 2, my lord. Page number 95, my lord, page number 95, my lord. It was addressed from Director SCRT to, my lord, Secretary to the Government of Assam Department of School Education, my lord. Subject, my lord, demand of withdrawing of manuscripts of Vishnupriya Manipuri language book submitted to the SCRT by Nikhil Vishnupriya Manipuri Sahitya Parishad, Assam, my lord. It was later dated on 19/5/2023, my lord.
Yes.
The organization of the
My lord, my lord, our letter, my lord, may I read, my lord? With reference to the subject cited above, I have the honor to state that SCRT Assam has been developing textbooks and other teaching learning materials in different languages, including Vishnupriya Manipuri language. And the relevant sentence, my lord, starts from, my lord, towards the bottom, my lord. The list of the organizations representing the community are: number 1, Vishnupriya Manipuri Ganasangram Parishad and Nikhil Vishnupriya Manipuri Students Union. That is number 1, my lord. Number 2, my lord, the Nikhil Vishnupriya Manipuri Sahitya Parishad, Assam. Number 3, Vishnupriya Manipuri Sahitya Sabha, Assam. Number 4, Vishnupriya Manipuri Textbook Production Committee, my lord.
Number 5, Nikhil Bishnupriya Manipuri Mahasabha. And number 6, my lord, Bishnupriya Manipuri Bhasanjan Pariksha Parishad, my lord. Demands of the organizations are enclosed at Annexure 1, my lord. Different demands, my lord. So, in terms of the pair being made in this petition, let there be a committee of the SCRT.
Yes, my lord.
My lord, that matter is
Pending before the government.
pending before the government, my lord. We have already communicated with the
Yes.
personal secretary to the education minister, my lord.
Let my lord government, with the most powerful body, my lord, constitute a committee, invite all of them, analyze it.
Government means who?
Government in the secretary to the government of Assam in the education bracket.
My lord, may kindly.
Where SCRT will also represent, we will also represent. Actually, IMA has got no role. IMA, because of the tussle matter, this mother organization has to come to court. Otherwise, it is not nowhere in the sin. This petition is not in sin. Because just to solve the problem faced by the children and the guardian. We are intermediary.
May I submit, my lord?
India again the
Already, I mean,
by implementing my lord,
yes, the Minister of Education.
5, 6, 7 parties. I'm them all of them respondents. Indo-Aryan experts should be linguistic.
No, my lord. I don't know, my lord, what senior counsel submits, my lord.
He is getting
No,
hot. He knows.
he's getting- The thing is,
What is happening to matter of government?
Mr. Sinha,
my lord,
the matter is.
You are playing politics and children are suffering. What is this?
Department of School Education.
yes, my lord.
Let the.
I am agree with that, my lord.
Secretary.
I am agree with that, no problem. But who is he, my lord?
No.
He is he neither Saitya Sabha nor Saitya Parishad.
Secretary will decide.
Secretary, I agree with that, my lord. But my lord, wherefore this organization comes to the before this honorable court?
Because of your
is
fight, the intermingling of your affairs.
You are the allied organization of that, my lord. Your lordship just read out my that one.
No, not necessary. We are disposing of this petition by directing the.
Yes, my lord. Government will take, government will take the decision, my lord.
Carried out within a period of 3 months from.
Yes,
today.
Father. That's why, short prayer,
Yes,
short prayer.
Mr.
Yes, here we have, in fact, we have filed a representation before NCRT that a committee should be constituted for this matter here.
Your lordship will that's my lord, just okay. I agree, my lord.
I
with that.
am for business.
Only the thing is that only the thing is that where from the grammatical contrast has come, they have make it out, my lord. Grammatical contrast. SCRT did not, my lord, make any comment of it. There is no grammatical contrast, my lord.
Let the committee
The
decide, madam.
petition you will file.
There is no point in arguing further.
The writ petition not maintainable, man. What I find
Development is also coming, my lord. One, my lord, latest circular by learned man in the item number 6 referred, my lord. This is true, my lord. It is as per this circular, my lord, whoever even, my lord, file any writ petition, my lord, challenging this OM, my lord, pending writ petition. That should be pending writ. He luckily, my lord, filed just 2 days before, my lord. As per this circular, my lord, if anybody file any writ petition before, my lord, 30/8/2024, they are also allowed to submit their biodata, my lord. They will consider before the SLC, my lord. And this is circular, lordship, my lord, just may have a look, my lord. So, my lord, it is, though it is pending, my lord, before the SLC, as per this circular, also, my lord, this case may be considered, my lord. This hold on.
Thank you. Thank you. Sir Terry, do you have any objection?
Lordship, since the matter has been in that DLC dated 28/5/2023, since that is, so I actually wanted to take the recourse of that clause 10 of the OM, but that won't come into here because already it has been, yes. So, but the petitioner has not annexed the NOK, which is vital because taking that immediacy and harness, because I don't know how much the NOK they have and whether some of the NOKs might have been employed, your lordship. So that may be recorded, my debt submission.
Mr. Terry, is
Yes,
there
your lordship.
any requirement in the memorandum in respect of furnishing NOK?
Lordship, the office memorandum says that about the harness, your lordship. So when
Is there any requirement of furnishing NOK?
that will be required, your lordship, because otherwise three NOK they have. Yes, your lordship.
But is it provided in the OM?
In the OM, but
All necessary, my lord, documents they received in the DLC, my lord.
DLC has received.
PC, my lord. Then, my lord, they process file, my lord. This is their standard procedure, my lord.
If the DLC has considered all the documents, then but the requirement of submitting the next to kin certificate.
lordship, in the accruing circumstances, I'm this because
You submit
yes, that may be that because yes, that aspect if
only
they
one member of the family can get the benefit.
yes. And if your lordship,
Generally, my lord, SLC, my lord, reviewing the entire matter again, my lord. Therefore, SLC, my lord. District level
what
and
I'm
state
intending to submit, perhaps your lordship, is that if the concerned deceased have 5 NOK, your lordship, if 4 of them are employed, so in that effect, if suppose similarly situated other petitioner who has 7 NOK but none of them are employed, so definitely that the one who has all of them are unemployed or who has that may be given the more benefit, your lordship. That is what I'm intending to submit.
Therefore, my lord, SLC, my lord.
Yes.
Deep level.
Sorry, I cannot appear. It was called again. My lord, item number 10 is basically a covered case, my lord. What happened with petitioners before lordship? In item number 10 and 11 are in fact similar. In 10, my lord, they are working in different colleges, my lord. My lord, they are all, my lord, non-teaching staff. Now, my lord, lordship may kindly turn to, my lord, page 140, sorry, 95, my lord. This is the 2019 rules, my lord. My lord, this is the, my lord, this is called, my lord, the Assam Education Provincialization of Services of Non-Teaching Staff of Pensionary Education Institution Act. Page number 89, it starts, my lord. Page 95, I will be referring to, my lord. It is the Assam Education Provincialization of Services of Non-Teaching and Venture Education Institutions Act 2018, my lord. Now, I'll be referring to section 6, my lord. It starts from page 94, Terms and Conditions of Service. Well, I'm concerned with notes 2, my lord. Section 6(2). 2, my lord. The non-teaching staff, my lord, has got it, my lord, 95, page number 95. The non-teaching staff whose services have been provincialized under this act shall get fixed pay as specified in the schedule with effect from the date of provincialization of the services as if they were fresh appointees and they cannot claim any benefit whatsoever in respect of past services rendered by them before provincialization, and in respect of pension shall be governed by the new pension scheme applicable to state government employees of the corresponding rank. However, the fixed pay shall not be less than the minimum wages fixed by the government from time to time under the provisions of the Minimum Wages Act 1948. Now, my lord, this particular provision was challenged, my lord, in a writ petition, my lord, before the Honorable Division Bench, my lord. And that order has been passed, my lord. Lordship will find that order at page 275. Number of series of writ petitions were there, my lord. It's a long, my lord. Order is not long, my lord. Number of parties were there. So 275, my lord, the order starts, my lord. My lord, kindly turn to page 277, my lord. Internal page 164 of the judgment. Page 277, my lord.
Yeah.
My lord, paragraph 8, my lord. Though the services of the petitioners are provincialized under the 2018 Act, however, under section 6(2) of the 2018 Act, it was mandated that the non-teaching staff whose services have been provincialized under the Act 2018 shall get fixed pay as specified in the schedule appended to the 2018 Act with effect on date of provincialization of the services. Then paragraph 9, being agreed with such pay, the provisions of section 4(1), 6(2), 6(3), 6(4) and the schedule appended to the 2018 Act are put into challenge in this writ petition, being unconstitutional and ultra vires. Now, my lord, there was a decision with regard to, my lord, the non-teaching staff, my lord, that has been relied upon. In paragraph 12, my lord, we have perused the determination in Mohor Ali Sheikh Supra under the 2017 Act. This was with regard to, my lord, teaching staff, my lord. Those teachers who were not having required qualifications mandated under the Act 2017 were brought under the fold of tutor with a fixed scale of pay subject to the acquisition of such qualification with a period of 5 years to get upgraded status of teachers or otherwise to continue as teacher with fixed pay. Such prescription was challenged in Mohor Ali Sheikh Supra. The coordinate bench dealing with such challenge held that by virtue of acquisition of the status as employees of the state government of Assam, after provincialization services, tutors will be entitled to enjoy the benefits of the regular scale of pay that have been extended to others employees of the state. It was further held that it will be incumbent upon the government to extend the regular scale of pay to the tutors. Finally, a direction was issued to the state to extend the pay scale to the tutors, which the state considers fit and proper, inasmuch as it was held that such determination as regards appropriate scale of pay cannot be entered in a writ petition challenging constitutional validity of a statute. In the given facts of the present cases, we are of the opinion that Mr. So-and-so, learned senior counsel for the petitioners, is correct that the same principles of law is to be made applied in the present batch of writ petitions, and directions may be issued in the light of the determination in the Mohor Ali Sheikh to extend scale of pay of non-teaching staff to the non-teaching staff whose services have been provincialized in the 2018 Act. Then, my lord, paragraph, my lord, the lordship will skip paragraph 14 and 15, my lord, paragraph 16, my lord, 279. Accordingly, paragraph 16, accordingly, the present batch of writ petitions stand allowed by holding that the non-teaching staff would be entitled to equal treatment under law as is extended to other government employees by virtue of their acquired status as employee of the state government. And since the other employees are enjoying the benefits of regular scale of pay, they should be paid a just scale of pay. However, we should we should be what should be a just scale of pay is neither a question raised before this court, nor we are inclined to enter into the state aspect of the matter in this writ petitions ordered accordingly. The determination of scales of pay shall be made within the period of 8 weeks from the date of certified copy, when a certified copy is already submitted before the competent authority in the education department by the petitioners. So, my lord, this honorable court held that we are entitled to similar scale of pay, but whatever will be the scale of pay will be decided by the state. So we are paying for a similar order, my lord, since we are, my lord, similarly situated persons, my lord. The only thing is that we belong to, my lord, the different colleges, employees of different colleges. We had not earlier approached.
State petition for
Pardon, my lord?
the petitioners of this state petition for
They are, my lord, all, my lord, working in degree colleges. Degree colleges. Colleges, my lord.
Then you are in,
We are, my lord, all, my lord, the junior assistants, senior assistants, etc., library assistant, my lord. In, my lord, this degree colleges, my lord. Degree colleges.
degree college.
Degree colleges. Same act is applicable, man, to us. We had not approached this on the court earlier, my lord, by challenging, my lord, but since the order has been, my lord, that particular provision has been, my lord, read down, and, my lord, to include that, we will be entitled to scale, my lord, scale of pay. So we are, my lord, paying for similar relief.
So does any objection?
My lord, kindly have page 32, my lord, para 25 and para 28. Page 32, para 25, my lord, of the petition.
Yes.
The petitioners have reliably learned that the benefits of regular scale may not be extended to the petitioners, which would be discriminatory and arbitrary as such. Unless this honorable court interferes in the matter, the petitioner would suffer irreparable loss and injury. And the next page, my lord, 33, para 28, it says that the petitioners has demanded justice and the same has been denied to them. Whereas, my lord, there is no representation, nothing is there that their case is, their claim has been denied, my lord. My lord, that judgment was for everyone. Similarly situated persons, my lord. It is not that only the petitioners who have challenged that my lord, provision or act will be benefited. But this petition has been, my lord, in my humble submission, filed in presumption, my lord. And moreover, my lord, the kindly have page 279. In 279,
Sir, does.
yes, my lord.
Let their case also be considered in the light of the observation made by the division bench of this court.
Or my lord may issue notice. In the meantime, my lord, appendices shall not be barred to provide them.
While learned friend is otherwise admitting, my lord. He's only on the technical ground that no representation of, my lord, something like that.
Because
otherwise, it's technically he's saying that we are also entitled to similar pays. It's applicable to all. So
Okay, then you file one representation there.
representation.
Closing the rate petition.
Yes, yes, ma'am. Yes. Lordship close it then, my lord. We'll file a representation.
Yes, that can
pass an appropriate order.
That shall be considered in the light
Yes,
of the
yes.
observation made in the division.
Yes,
Made by
yes.
that division.
Yes, ma'am. We'll do it. Look, the item number 11 is similar. Item number 11 only, my lord, they are, my lord, not, my lord, from the college. They are, my lord, from. They are senior secondary schools, my lord. That's why we have, my lord, to file two separate cases. They are senior secondary schools.
Whether their case also be considered.
Same.
Covered by the division bench.
Yes, but same act covers all.
With effect for secretary.
I'll be.
So any objection in disposing of the matter?
But I don't have any objection. Perhaps, my lord, this disposal can be given by the division bench because that was a challenge to the rule, my lord. In that petition, my lord, the earlier division bench order has been relied upon, my lord, saying that it's a perimetry, my lord, the similar is, and therefore it will be covered, my lord. Perhaps, my lord, I leave it to your lordship, my lord, because the challenge in that petition was with regard to the rule, my lord.
Rule, yes.
Rule. And in that context, my lord, division bench has said as in the 2018 teaching staff, for the teaching rules, as the division bench has already held that they will be entitled for a fixed pay, not fixed pay, but a scale of pay. And therefore that the same observation will be also applicable for the non-teaching staff in the 2018 non-teaching staff rules. So rest I leave it to your lordship, my lord. In my understanding, my lord, it ought to have been before the division bench, my lord.
Not necessarily.
I leave it to your lordship, my lord.
Light of the law.
Already not the law, my lord.
So in the light of that decision, you examine the matter?
Yes.
They will
Because
represent-
my lord, your lordship will kindly see in the order that has been passed, my lord, which they are saying that similar order to be passed. There, the honorable division bench has also taken note of that there is a review application filed in Mohor Ali's case, my lord. So we'll have to file a review in that order also, because it is being said to be covered. So if it is then, if the review is being filed, it has to be filed before the division bench.
The division bench passed the order in spite of the review.
considering that even the review was pending, that then also it passed the same order. So therefore, my lord, it's not.
No, in fact, that was the deliberation before the court, my lord. That. Rest I leave it to your lordship.
Oblige, your lordship.
For admission.
Lordship, petitioner before your lordship applied for the LP school teacher. For the. Where is Mr. B. Gogoi? SSA? Anybody agreeing for SSA? B. Gogoi. After some time, let the council.
21, my lord. That instruction, my lord, I did not receive the instruction. It was received, my lord, by assembly system, my lord. It escaped from my notice, my lord. So,
Okay.
my lord, the cost part of your lordship rest can be taken up.
Okay.
No, no. My lord will fix it as it is, my lord. Only the cost part, my lord.
Later on, let's say posting. Internet council for the respondent, secondary department, secondary or elementary?
My lord, department, lordship will say Department of School Education.
Department of School Education. Submits that, Mr. Assembly state. Internet standing council for the department and receive the instruction. And the same was not informed to you.
Well, it escaped my notice.
That same escape from his office, that has the cost part, cost imposed by this court may be waived accordingly, taking note of the submission. No, posting and council court of the order imposing cost upon the imposing cost, stands recall. The submission. The instruction, you have received
Madam,
written
yes.
instruction?
The instruction is, my lord, the Department of School Education
Shall be taken with the record as an extra X.
Well, I appear for the office of the accountant general, my lord. I am also there in the matter.
So your presence will not be recorded now because the matter was taken in the first half.
Fine.
You remain absent.
I missed it, my lord.
highly grateful.
My lord, it may be fixed on 22nd, my
The
lord.
date, same.
That will remain.
Grateful, my lord.
Plus,
Lordship, in this case, Lordship, non-payment of pensionary benefit to the unmarried daughter, Lordship, and also death benefit to the family of the incumbent, Lordship, who expired while in service, Lordship. So on the other day, they have submitted that they have not received any application from your end.
Lordship,
that improper format.
Apart from
That she complied in the meantime.
file,
Lordship.
when
It is in the month of Lordship June.
June,
Lordship.
have you placed the same on the record?
No, Lordship.
No.
I may be allowed to file additional application. Lordship.
Okay, third is allowed also, third, but that means the paper for the implemented part. Some other submits them. Also, so ordered it in 16/5/2025. Same instruction. And that the in some effect the petitioner has compared his files. Her or his her application in proper format, including the relevant document, for which the papers includes all the relevant documents for the children. However, Mr. Conductor, some step. He may be granted some time to bring on record the said application by filing an additional affidavit. Fair it allowed, that is something on. Okay. Okay.
Obliged. Obliged.
Okay. That is- So-
Yeah, please, Lordship.
Yeah.
This petitioner lordships, he has successfully challenged the appointment of a principal. This honorable court not only set aside the appointment of the candidate, also set aside his degree, postgraduate degree. Thereafter, 4-5 of litigation followed. Then I was finally appointed as a regular principal on 16/9/2024, 11/9/2024, and I joined on 16/9/2024. In this repetition, lordship, I am claiming notional benefit because of the deprivation in the year 2017. And lordship, at presently, lordship, my prayer would be, lordship, to immediately give me the pay protection and the scale of principal attached to the post. Lordship, I'm
Sorry,
still
Your Lordship.
receiving my salary in the
Please,
my
Your Lordship.
suspensive post of postgraduate teacher English. On the very first day, this honorable court asked them to obtain instruction why you have not paid his salary in the scale of in the post of principal. That instruction is not forthcoming, lordship. And I'm going to retire, lordship, in January 26.
26 times. Sir. Maybe.
For the last 1 year,
Your Lordship, kindly grant us 2 weeks' time, Your Lordship, to file the affidavit, Your Lordship.
lordship, let them file the affidavit in respect of the notional benefit. Lordship, let them obtain the instruction why I have not been paid the salary, because inspector of
That, Your Lordship, that instruction, we have to file it again, Your Lordship, in affidavit, Your Lordship.
No.
We'll be filing our affidavit. Kindly grant us 2 weeks' time, Your
inspector
Lordship.
send the proposal long back, lordship.
Appointed as regular principal. Why the shell of pay has not been granted to him?
Lordship, my appointment letter may kindly see at page 93.
Your Lordship,
Scale of
instruction,
graduate
Your
Yes,
Lordship, I received it, Your Lordship. I would like to place it, Your Lordship. Hard copy is not available. I would like to place it soft copy.
You
It-
send it by email to the court master.
Yes, Your Lordship.
Where is your appointment letter?
At page 93, Lordship.
Itu photo mas. Dilu. বুঝছে বুঝছে চাওক না দুটা কপি দিব বুঝছে মোৰ ইয়াৰ পৰা গ'ল কোৰ্টত চাবমিট দিম মই তাতে আছে
দিব নেকি?
Your Lordship, Deputy Director of Secondary Education, Assam. Your Lordship, written that letter to Inspector of School, Kasar. And there, Your Lordship, subject has already been given, Your Lordship, regarding pay protection in respect of Gitashri Das, who is the present petitioner of Principal of Swarna Lakshmi Higher Secondary School, District Kasar. And reference letter, both the letters has been given, Your Lordship, that is government letter so-and-so dated 28/2025. And another one, Your Lordship, pay protection, which was issued, Your Lordship, on dated 11/11/2024. And there, Your Lordship, you was requested that I'm given direction to inform you that the government white letter so-and-so above reference has requested to provide the following documents regarding pay protection in respect of the petitioner, that is Srimati Gitashri Das, Principal of Swarna Lakshmi Higher Secondary School, District Kasar, NOC from higher authority, service confirmation report, revised pay structure, and last pay certificate. You are therefore requested to submit the above mentioned document at an early date on word submission to the government, Your Lordship. So it was lying, Your Lordship, because all those, Your Lordship, documents are necessary to submit regarding pay protection. So, Your Lordship, that's why, Your Lordship, we are kindly grant us some time, Your Lordship, as the following documents are necessary. Service confirmation report, revised pay structure, last pay certificate, and NOC
Doctor,
from
in all
higher
other,
authority.
in other cases,
Cooperation
cannot
should
take-
be given, Your Lordship, because here, Your Lordship, how can one pass the, Your Lordship, pay protection?
Okay.
It's not,
What is your agreed care?
Lordship, in respect of other principals, they did not take 1 year. It is almost 1 year, Lordship. In September 2024, I was appointed as a regular principal.
No, what is your agreed care in this petition?
Lordship. Page 22, Lordship. Prayer number 1, to allow the scale of regular principal to the petitioner with incremental benefits rate of account when other income is present. To pass a similar order, and that similar order in respect of notional payment. Notional. And lordship, from the instruction which my learned friend has read, that inspector of schools proposal was sent on 11/11/2024. You have on 11/11/2024, lordship, the proposal was sent. Then why they are taking it so long, lordship?
So whether these
I'm going-
documents are furnished
Yes, lordship.
along with that proposal.
Yes, yes.
Then your lordship, they have getting that receipt also, where whenever they are submitted those documents regarding that, your lordship, one receipt copy has been signed by the concerned department, then show that receipt copy.
Yes, receipt copy, yes, I have. I also have a receipt copy. That inspector's letter, lordship, I have. The director has received it, lordship, I have note down. Director has received from the
Okay.
inspector's proposal on 11/11/2024.
Where is the hard copy,
And
your
DSC,
lordship?
DSC Assam has written to the government on 16/11/2024.
Oral submission.
If already the documents are furnished, then why the same are not
Yes.
considered?
Lordship, that part he has submitted by orally, your lordship. He has not given any hard copy, your lordship, any instruction. I am submitting with all hard copy, your lordship, not by orally submission. So your lordship, kindly grant us 2 weeks time, your lordship. In the meantime, I may allow to obtain latest up-to-date instruction whether verification of documents has done or not. That much
Lordship,
preparation should.
Lordship, I have got two documents, lordship, wherein lordship, the inspector of schools has a receipt copy from the director's office that he has sent the proposal. And lordship, there is a communication from the director to the government that is of 22/4, that is of lordship 16/11/2024. 11/11/2024, highest proposal, which was received by DSC Assam on 16/11/2024. And lordship, the director has written to the government on 22/4/2025. Those two communication I have. The rest of the other things will be done by the department also. How can, my prayer is to, I'm entitled for the regular principal scale.
Oh, okay. Or Mr. Status learned so hardness. He does learn concept for the respondent. Does learn for the
1 and 2 respondents.
different department. That's part one letter written by the Deputy Director Secretary Education Assam, addressing the Inspector of the School forward SSC from higher authority, service confirmation report, revised pay structure, last pay certificate. Last pay certificate on the basis of the letter of the Deputy Secretary to the Government of Assam, Department of Education, addressed to the Director of Secondary Education, Kalipara, on 20th/8/2025, requiring the appointment of. However, Mr. Das learned counsel for the petitioner submits that the inspector of the school has already submitted the proposal by the letter dated 11/11/2024.
Lordship.
And reference of the said letter finds mentioned in the letter of the inspector of the school. In the letter of the Deputy Director of Secondary Education, addressed to the inspector of the school. And under such circumstances, Ms. Das Learned Standing Council is directed to obtain the latest status within a period of 1 week from today.
2 weeks time may be granted, your lordship. Kasar is there, your
No,
lordship.
no.
From Kasar.
You have to obtain instruction from here,
Yes.
this court. Place the matter on for it. The instruction on the letters dated 6/9/2025, then 20th/8/2025, set the markers and X and Y shall be checked with the record. When?
16th.
Six.
Obliged, Lordship.
Deeply obliged. तुम्ही लोहित
But can this matter be taken up on Monday, my lord?
But content, my lord,
Here is an order, my lord, where Honorable Court directed us to give the benefit to the petitioner as a deemed provincialization under the Struck Down Act of 2011, my lord. So some decision was taken in respect of the posts which are already been sanctioned prior to the act being struck down, my lord. So I'll have to take the updated instruction, my lord, at what stage, my lord. In the last order, my lord, I have made a submission, my lord. There is an ongoing decision taken in respect of such kind of candidates, my lord, whose provincialization were left out under the 2011 Act.
Already
2 years,
years elapsed.
2 years, my lord.
Difficulty is, my lord, there is a
Difficulty, if you have any difficulty in implementing the order of the court, you file a review petition.
I understand, my lord.
You file an appeal. Having not availing that facility.
That's the difficulty which we are facing, my lord.
Then-
Otherwise, there is a mandamus, and that mandamus is absolutely in violation of the Supreme Court's direction. Anyways, my lord,
Our
for
service,
some of the candidates, my lord, if we can accommodate, we have taken a decision, my lord.
our service was, my lord, left out, my lord, because of typical error of the department. It was rectified, submitted fresh proposal in 2015. The school has been
No,
provision only, only grade.
Violation of the direction issued by the Supreme Court, you go for a review or appeal.
My lord.
Why you are slipping over the matter?
And these two petitioners, they are grade 4, my lord. Grade 4 employment. All teachers have been provincialized.
Third, sir, are they turn it on for the petition? That is a boxing. Turn it
For the solution.
put on the paper. The boxing submits them. The process is going on and he may be granted some time to obtain after the allowed. It's the matter on.
22nd.
In the event of failing to apprise this court about the latest status of the process, then the court will consider directing the contempt notes to remain permanent present before court.
Obligation.
May I please, your lordship, before my senior start, my lord. I'm seeking only 1 week time, my lord. I have already prepared the affidavit, my lord. Instruction received, I prepared the affidavit. Within a week, I will file, my lord. No, in the meantime, what happened, my lord, he is appearing for all respondents. Yes, yes, my lord. Let the matter maybe come for admission. I'll be appearing for all the respondents. And my lord, in earlier occasion, I think the principal.
Court, Mr. Porua, Colonel of the Court of the. Yes, the. So does submit that. They've already prepared the affidavit. That will be filing first. And under such circumstances, does to place the matter after a week. After a week. Accordingly, it is provided that this is a with the matter. And in the meantime, Mr. Dobbs will file his affidavit.
Interim order may be extended. Interim order passed on 15/11/2023 may be extended.
Okay, interim order passed on itself.
Obliged, your lord. Well, here I have received verbal instruction that there is a meeting this evening with the senior standing council of the department regarding this issue, to resolve the issue. My lord.
My lord, now, my lord,
Let it be on next Monday.
Well, 10, can it be 10 days, my lord? If, my lord, any
If
positive,
meeting is scheduled.
today, my lord, if any positive outcome is there, my lord, that will, my lord,
Positive, negative, what is the question?
my lord, my lord, my lord. After a week, my lord, no issue, my lord.
my lord, it may be on, my lord. 10, my lord.
10.
Yes.
Okay. Third is the conductor, third is council for the minutes. Also hard is the meeting for us. Third is nothing council for the third is council for the contempt. Mr. Bora submits that. To the meeting is being scheduled to resolve the matter. And if let's go testing the matter after 10. However, it is provided that this is complete the matter on next Monday.
Then, my lord, 16th.
16.
I am declared.
Obliged. Speak with your lordship. Lordship, the order filed is that page number 17 and 18 of the contempt petition.
So we have filed our affidavit.
When?
My lord.
When?
Lordship, we received a copy of the affidavit.
Last
Yes,
date of filed.
last week filed here.
On the last date we filed our.
And their contention is that Rule 12 of Assam Secondary Education Lordship, that the age of the petitioner is 57 years and above. But our thing is that we applied for the post of principal in search, and as per paragraph number 24, Lordship, in the contempt petition number 24, kindly presence 24, Lordship. Paragraph number 24, page number 17, Lordship. The petitioner number 1 herein, admittedly being the senior most serving teacher in the sage school, and admittedly also being the senior to the respondent number 4, herein a legal right has accrued to the petitioner number 1 to hold the charge of post of principal of Nazira Girls Higher Secondary School, Nazira, and accordingly it is held that the petitioner number 1 could not have been deprived of his right, and the petitioner number 1 having been already held.
You are referring to page number?
Page number 17 and 18, Lordship, of contempt case, contempt petition.
Paragraph number?
24, Lordship. 24. The petitioner number 1, admittedly being the senior most serving teacher in the sage school, and admittedly also being senior to the respondent number 4, herein a legal right has accrued to the petitioner number 1 to hold the charge of post of principal of Nazira Girls Higher Secondary School, Nazira, and accordingly it is held that petitioner number 1 could not have been deprived of his right, and the petitioner number 1 having been already held by this court herein above to possess the requisite mandated eligibility criteria under the provisions of rules holding the field. It is petitioner number 1 herein who is now required to be allowed to function as principal in charge, Lordship. Kindly note this point, principal in charge of the sage school in place of respondent number 4. And the direction is at paragraph number 26, Lordship. In view of the matter, the Director, Secondary Education Department is hereby directed to issue a formal order allowing the petitioner number 1 to hold the charge of principal in charge, Nazira Higher Secondary School. Now, this order has been violated, Lordship, and instead, in their affidavit in opposition, they prescribed sub-rule 3 of Rule 12 of Rules 2018, Lordship. This point was never raised in the writ petition.
They never raised this question of age in the writ petition, Lordship. Neither they challenge the order opposition. Paragraph number 8. 7-8, Lordship. Page number 23.
Page 23.
Page 23.
Paragraph number 7.
7-8, Lordship. The contention of the contender that the age of the petitioner is 57 years and above. Lordship, these points for the first time, Lordship, this point has been raised in the court. The question of age was never been introduced to the court in the writ petition, Lordship.
Oh, it's a writ petition. You have filed the affidavit in the
Hello. In fact, my lord, if your lordship will kindly see the order that was passed by this honorable court, the issue in that writ petition was never this, my lord. The issue of determination before the writ court was whether under the Assam Civil Service Conduct Rule 13, whether that degree would be a valid degree or not. Your lordship will kindly see paragraph 20 of that order, my lord. First, paragraph 20 and 21, my lord. May I just read? Paragraph 20, my lord, finds. The respondent authorities, by referring to the provision of Rule 13 of the Assam Civil Service Conduct Rules 1965, had contended that the petitioner, having so pursued their master degree without obtaining prior permission and or NOC from the department authorities, the master degree as acquired by them is invalid, and the petitioner, not having possessed requisite qualification as mandated under the provisions of Assam Secondary Provincialization Service Rule 2018,
for appointment to the post of principal of the school in question, they would also not be entitled to hold the state post of principal in question on an in charge basis. The issue, para 21, the issue that arises in the present proceeding is as to whether on a mere violation of Rule 13, the master degree so obtained by the petitioner herein would be rendered invalid and would be not reckonable for consideration of further service benefit, including appointment promotion to them in their service career. Where 22, is the Honorable Court has relied upon the earlier judgments. Now, my lord will kindly see paragraph 23. A friend has read paragraph 24. Paragraph 24, paragraph 24 declaration has come from paragraph 23, my lord. Applying the ratio of the decision of this court in the case of Tankeshwar Supra, it has been held that the MA degree acquired by the petitioner, having been so acquired from a recognized university, the said degree is otherwise valid and acceptable in law, and accordingly the petitioners are held to have fulfilled the eligibility criteria as mandated for recruitment to the post of principal Nazira High School under the provisions of Rule 12(3) of the Assam's Education Provincialized Rules, Service Rules 2018. Now, my lord will kindly take Rule 12(3), my lord, for a moment.
No, I am not sitting in review.
No, of course not. No, therefore, my lord, the declaration, my lord, now, lordship, the direction was to the director to
Court can hold the relief. Then here it appears that the court had hold the relief. You carry out the order.
no,
Compliant order before this court by next day.
my lord, in fact, the director, my lord, who has been directed, my lord, has written to the government in terms of the verification that has been done by the director. While in process, it has been found that 12(3),
Why don't you file?
well,
the
we have already sought an approval from the government for filing a review, my lord. So we'll be filing a review, my lord, shortly, my lord. Lordship maybe possibly Monday, my lord.
This order was never been challenged by the respondent authorities. And the
In
question
para
of
10, my
review
lord,
or-
will kindly see in by
Lordship,
affidavit, my lord.
This come here.
Paragraph 10, my lord.
Sir, the judgment was passed on 13/6/2024, Lordship. It's been almost 1 year. More than 1 year.
Paragraph 10 of the affidavit, my lord.
13/6/2024. And the question of filing review or other thing has come up right now, Lordship.
Because of course, my lord, because while moving forward to comply with the order, when the document verification was done, it was brought, only then it was detected that on the date when the post was fallen vacant, on that day, he has crossed the 57 years. And that's a mandate of 12(3)(5).
Lordship, it is
Paragraph
number
10,
20.
my lord, by later dated 16/8/2025, my lord. An approval has been sought from the government for filing a modification or review of this, the judgment of the Honorable Government. Paragraph 10 of the affidavit.
Where is the approval you told the
But approval is still awaited from the government. And the government is not a party, my lord. The direction was to the director, my lord.
you comply with the order and for
Lordship will give us 2 weeks time, my lord.
no.
Otherwise, my lord, your lordship will.
But Mr. Your name
US Bora. US Bora.
learned counsel for the petitioner and also our standing counsel. No, learned counsel for the company. And also part of the affidavit filed by the contemptor. Then it appears that the stand taken in the affidavit is far from satisfactory. The contemptor having not filed an appeal or a review petition against the order of this court dated 13/6/2024 cannot be allowed to take such a stand in this contempt. Accordingly, the contemptor is directed to comply with the order of this court dated 13/6/2024 and place the order before this court on that day.
Can it be 2 weeks, my lord? Because Lordship will kindly appreciate one thing, paragraph 10, my lord.
17. In the event of failing to produce a compliance order for this note on 17, the court will consider directing the concerned to remain present for personally.
Most obliged.
Item number 36.
Here, matter is pending before the personnel department right now, my lord.
Anybody appearing for personal department?
Personnel department government. And it was placed on 6/6/2025.
Where is the document to show that the matter is pending before the personal department?
Yes, my lord. On last occasion, I have placed on documents where it is stated, letter dated 21/8/2025. On last paragraph, however, and it is written in the last line, Department of School Education has referred the case of the petitioner to the personnel department on 6/6/2025. And this is my today's instruction here.
So, madam, can you obtain instruction that what is this file is pending? The
Lordship,
of the
I can-
department?
Lordship,
When?
one week time may be given, Lordship.
Oh, you can obtain instruction over phone only.
Friday.
Friday, Lordship.
Friday is holiday. Thursday,
Holiday, Thursday. Thursday, okay, Lord.
Thursday. Thursday, sir, P. Sharma, Lord and Council for the. You, Sharma, Lord and Council for the Concept of. But producing a letter dated 6/9/2025 issued by the Joint Secretary to the Council of the Department of Education, addressing the Senior Council. Submits that the matter has been placed before the person.
What's up with the report?
6/6/5. Seeking views, suggestion regarding age conversion of the petitioner. And now the matter is under examination of the personnel department. Accordingly, taking note of the proceed submission of Mr. Sharma, learned counsel for the contempt of this as for learned for the person of the department is requested to obtain up-to-date status of the proposal of the petitioner pending before the pending in the personal department and apply this court on Thursday at 2 p.m. The letter produced before the court today by Mr. Execute the report by marking it as annexary. This shall also reflect the name of Ms. Kumar in the cause list.
Next, Thursday, Lordship. Thursday. High level. Nine. Thursday. 11. May I present, Lordship? As per office number 49/2025, service is awaited upon respondent number 1. And Lordship, respondent numbers 2 to 6 have also not filed their affidavits. Those will be required. Of respondent numbers 2 to 6, more particularly of respondent number 5 and 6, their affidavit will be very much necessary.
So Chakraborty, you are.
I appear for respondent number 7. My lord, I am in receipt of a copy of,
Not in 5 and 6.
no, I'm for respondent number 7. Private respondent number 7. I am in receipt
But the
of,
service completed in respect of 5 and 6.
Lordship, yes, on last occasion, plus departmental counsel P. Saiki appeared. Lordship, 5 and 6, the learned government advocate P. Saiki appeared for 3, 5 and 6. If your Lordship kindly produces the first order. 410
But in respect of respondent number 1,
services awaited, Lordship.
awaited.
Awaited.
What to do? You want to take press step?
Lordship, as per direction of Lavazima Court's order on 29/8, fresh steps has been taken on 30th of August. Recently, Lordship.
Listen,
We have already taken fresh steps.
we'll list the matter after 1 week then.
Lordship.
in the meantime, my lord, I make a prayer in regard to 2 affidavits filed by the petitioners. I have to respond, my lord, because there are some factual aspects, so I need to file my response to both the affidavits, my lord. May I be allowed?
Lordship, and the affidavit of respondent 5 and 6 may also be directed to file their affidavit, because that will be necessary for deciding the issue.
The counsel,
I understand, Lordship, but that probably my learned friend will also agree that will be relevant.
My lord, may I make an observation
Lordship.
that affidavit may come from respondent, because since they have already entered appearance,
or Mr. A. Chakraborty, or I counsel for the. Or C. Chakraborty. Or I counsel for the respondent number 7.
7.
Office note dated 4/9/2025 indicates that neither required nor answered number 1. Presence and leave the matter after 1 week, awaiting service report upon respondent number 1. In the meantime, respondent number 5 and 6 may file their affidavit in opposition.
And I may file my affidavit to their respect.
Mr. Chakraborty also submits that may be allowed to file reply
Response to 2 of their affidavits, my lord.
response to the affidavit, additional affidavit.
Additional affidavit.
And affidavit in reply filed by them. I have filed my affidavit in opposition, to which they filed reply. I have to file rejoinder in that. And in additional affidavit filed by them, I need to file my objection, my lord.
Reply in objection to the affidavit. Additional affidavit. Then affidavit in reply filed by the petition. Where is allowed. Is the matter after 1 week.
My lord,
Alright.
can it be after 2 weeks, my lord, if it is not inconvenient?
2 weeks,
Okay.
probably the vacations will approach, it's only the.
Okay, after vacation.
Lordship, let it be before vacation, if 2 weeks.
Before vacation, my lord, it can be 2 weeks.
After the rest, less the matter.
My lord, my lord.
Oblige, Lordship.
May I please? My lord, I have taken instruction from my client that the director has complied, but the inspector of schools has not issued the follow-up direct compliance, my lord. He has to follow the direction of the director, my lord.
Director has complied with.
Director has complied with, and thereafter the matter is,
Director of the school has not complied.
yes.
My lord, director has forwarding his speaking order on 2/9/2025 to the inspector of school test board. So my lord, sometime may be granted and sometime required, my lord, here. At least 2 weeks, my lord.
Mr. Purkar. Sir, forecast of subjects that director. Elementary education or
Secondary,
secondary?
secondary education, my lord.
Elementary education that complies with the order of order. But
And this is the
the
provincial
inspector
order.
of school as per sonnet for
24.
has not complied with the order of this court. However, it's the informal verdict council. Put the contempt or price for 2 weeks time. There is accordingly allowed with the method. After 2 weeks,
Pleasure.
My lord, today, this higher secondary council has issued an order. Now they call it Assam State School Education Board. My lord, this order is, my lord, contemptuous in my humble submission. Why, my lord? The same very grounds were taken while refusing us the earlier order. And after taking note of all these grounds, my lord, this order was passed. So, my lord, if your lordship would kindly come to the impugn order, order in respect of which we are alleging contempt, my lord will kindly come to page number 83. Paragraph 34.
yes.
Last minute. In view of the foregoing discussions, I am of the considered view that the respondents are deserved to be directed to consider the case of the petitioner for according permission and allow to conduct admission for higher secondary class 1 classes onward in their respective school. Accordingly, the respondent authorities, namely Secretary to the Government of Assam, Secondary Education Department, Director of Secondary Assam, as well as Assam Higher Secondary Council, that is, are directed to consider the case of the petitioners within a period of 3 months, 3 weeks from the date of receipt of a certified copy of this order. Now, this is important. Consequently, the impugn letter dated 14/9/22 issued by the Secretary to the Government of Assam, Secondary Education, the impugn communication so-and-so issued by the Director of Assam, and the impugn order dated 8 were issued by the Director of Assam are hereby set aside and quashed. Same very grounds were taken in these communications, my lord, which were quashed by the honorable this honorable court. Now again, the same grounds they have argued. Milord, what I propose to do, Milord, today it may not be possible as time is less. What I'll do, Milord, I'll bring on record those orders. I'll just file a small affidavit, let the matter be taken up on next Wednesday, Milord.
Yes, my lord, I am appearing for respondent number 3, my lord. For Assam State School Education Board, my lord. And as per in respect to the order of this honorable court, my lord, this order was passed on 1/7/2025, my lord. My lord, last paragraph, my lord, the board, whereas the board upon due examination finds itself unable to accede to the request of the petitioner institution as the institution currently do not hold the requested provisional registration and affiliation of SU. Comply with the order of this court,
Yes.
not the request. My lord, now, my lord, the government, my lord, they need to submit the my lord, prior permission from the government, my lord.
Milord, in an appropriate case, well, Lordship directs consider their case, then it is okay. Then it will not be contempt. Then I'll have to challenge the order which my learned friend has placed. But on the same very ground, those 3 orders were passed. Those 3 orders are not on record. That's why, Milord, I propose to bring on record those 3 orders. Lordship will kindly have the matter next week. Or Friday. Let it be on Friday next, Milord.
Friday, Monday.
Not a Friday, no, following Friday. Fine.
Or Mr. K. Suspended by faculty. Learned not to put a petition. Or T.K. Roy. Learned not to put a contempt. The reports of hearing, sir. Roy has produced one order dated 1/7/2025 passed by the Secretary, Assam State School Education Board, Division 2, Bamani Madam Guwahati, and submits that the order of this court has been complied. However, Mr. Chaudhary, learned counsel for the petition, submits that the Secretary, no, the contempt court has rejected the
On the same very grounds which have been interfered by this honorable court. my lord. Earlier also that was the ground, that there is no permission.
refused to comply with the order of this court on the same ground which was rejected by this court
Yes,
earlier on three occasions.
yes,
In three different petitions.
yes. Well, I'll bring on record those three orders which were interfered by the learned single
In
judge.
different petition, different
In,
petition.
in earlier round of litigation,
in
my lord,
earlier
in the
round of
judgment,
litigation. And he pressed for granting him 1 week time to bring on record those three
orders, my
decisions,
lord.
orders. Where is accordingly allowed, this is a matter on
22nd, my lord.
22nd.
Yes.
Deep left.
Lordship, Mr. B. Gogoi, he's on legs, Lordship, but Lordship, if Lordship wants, Lordship will continue, he'll be on, till then Lordship, I'll argue on the affidavit has already been filed.
What is the pair, Mr.
Lordship, for setting aside the impugned order, there is an order passed by the authority. And Lordship, my case was that I applied for the post of LP school teacher, Lordship. My document was verified, but my name was not included in the select list on the ground that my date of birth was tempered. Then we preferred a writ petition, and before filing a writ petition, we made a representation to the authority to consider our case, as there is no temper in my date of birth. But in the representation filed by the petitioner, which was disposed of, and that order is challenged in this writ petition. In the order passed by against the representation, Lordship, they pleaded a new case that I failed to produce the document on the relevant date while the document was verified. That is a false plea. It is taken at the belated stage, Lordship. Lordship, kindly come to page 18, Lordship. Annexure 3 is the online application for Lordship.
So why your petition was rejected?
Rejected, Lordship, that is Lordship impugned order on the way that may I read, Lordship, authority portion of the order. Coming to the facts of the case, it is seen that
Paragraph number.
Lordship, page number 29, annexure 10.
Property portion.
Lordship. Down below, Lordship, coming to the fact of the case, it is seen that Srimati such and such applied for the post of assistant teacher contractual in respect of LP school. However, during district level verification process, candidature of Srimati such and such bearing such and such number would not accepted due to overwriting on her date of birth. In admit card,
and pass certificate of the HSLC examination. The petitioner such and such failed to submit any duplicate copies of the aforesaid document on or before the last date of the verification. That is not correct, Lordship. While the document was verified, her document was verified and it was found genuine. Only on the ground that her date of birth was tampered, on that ground, her name was not included in the select list. Lord. HSLC documents on that is 31/7/2017. As the verification of document including the admit card and HSLC examination was to be done by the district level screening cum verification committee up to the 31/7/2017, and as Srimati Sumana Das did not submit the duplicate copies of the aforesaid document up to the last date for verification of document, her candidature could not be considered for the post of assistant teacher. This was the ground taken. But actually, on the date of verification, my document, I have submitted all my document, original document. It was later on lost. On 8/9, after verification, it was lost, and I have lost a police complaint, Lordship. Lordship, kindly come to page 23. Police inquiry.
Do you have the original copy of your birth certificate
It is lost.
and admit card?
These two lost. That's why I have filed a Ezahar on 9/9/2017. It is after verification of the document, not before. After the verification of the document, it was lost, and I immediately thereafter lost the police missing report, and thereafter, after verification, duplicate copy was Lordship issued
By
by the Sheba Lordship.
Seva.
Lordship.
Whether those documents are part of this record?
Lordship.
Page number?
Lordship. Lordship, it is at page 24.
20?
24, Annexure 6. And also, Lordship, date of birth, her date of birth was reflected at 27/12/1975.
No. This a duplicate copy of your certificate.
Lordship, it is page 24. It is duplicate, Lordship.
This was issued on 11/9/2017.
Lordship.
Mr. Das, no, Mr. Roy, is there any dispute regarding?
No, my lord. We have made clear, my lord, our stand in our additional affidavit filed on 23rd of January 2025, my lord. My lord, that document was verified, my lord, in the.
You go for respondent number 3 or
6.
And your
and the same
is at page number
page, running page 35, my lord.
35.
Yes.
Paragraph number?
Paragraph 2, my lord. That on receipt of the legible copy of the SLC certificate of the petitioner annexes Annexa 11, page 34. To the additional affidavit filed by the petitioner, the same has been verified with the records of the board and found to be tallied.
The impugned order is dated
Is that page number?
Lordship, it is page number 29, it is 21 to 2020. 21 to 2020.
Page number. No, there's a rejection order.
Lordship, it is Annexure 10 that is impugned in this writ petition.
Page number
29, Lordship.
29.
Lordship. Order dated 21 to 2020. Speaking order.
And your certificate was issued on, that duplicate certificate was issued on
Lordship. It is issued on 11/9/2017.
2017.
Lordship.
And you have produced that document before the mission director.
Lordship. But document, while document was verified on, my document was verified on 29/7/2017. On that day, original document I produced, not duplicate. Lordship. That time original was produced.
No, you see here. Page number 29.
Lordship.
Paragraph number 3. Overwriting over date of birth in admit card and pass certificate of SSLC examination. Then you have failed to submit any duplicate copy of the aforesaid document on or before last date for verification of document on 31/7.
That is under actually. That is not correct, Lordship. That time my original document was there. That original I produced before the authority. While the document was verified, original
So
copy
when the document
on
documents were
29/7/2017.
29/7.
And it was lost after 2 months after verification, Lordship. It was lost in the month of September, Lordship, after 2 months of the document verification.
And you did not submit the documents.
Interesting case, my lord. When the petitioner was supposed to place that, my lord, certificate, it was stated that, my lord, he has lost it. The police case was registered after the entire date was over, verification date. C now comes up with this particular certificate, be it a duplicate one. But, my lord, a competitive exam is a competitive exam. We cannot wait for some candidate that he has lost the certificate. He will come up with a fresh certificate. We cannot wait for that.
That is
our ground, my lord, entirely on that point. She was supposed to furnish the, my lord, documents from 27/2017 to 31/7/2017.
And my document was verified on 29/7, Lordship. That time, original document I have produced before the authority, document was verified, it was found genuine. Only on the ground that my date of birth was tempered. Initially, my name was not included in the select list, Lordship. But after filing representation, Lordship, and in compliance with the order passed by this honorable court, while the order passed against the representation, they've taken a new plea that on the date of the document verification, I failed to produce any duplicate certificate. That time my original was there. Why duplicate is required, Lordship? That date I have produced. Lordship also may.
You have filed a reply to the affidavit in opposition.
Lordship.
In which paragraph you have stated that you have lost the documents after 2 months of verification?
Lordship, it is, I have stated in my petition, Lordship, it was lost in the month of September. I have stated in my petition, Lordship. Statement is there.
Mr. Gogoi,
My lord,
the SEBA has also filed an affidavit in opposition,
my lord.
and they have confirmed that her date of birth in Annexure 11
My lord.
of their affidavit.
We can get it. On the allowance side.
তাৰমানে সেইটো আগতে legible নাছিল, এখন supplement দিছিলে।
Now, lordship, the difficulty is this, my lord. Original one petitioner is suddenly lost. Lordship will see.
That may happen.
No, no,
Okay.
It is after verification of document.
no, no. When on the day when it was verified, there was overwriting. We objected to that. We were supposed to give a clarificatory, my lord, document before the authority within the time frame, my lord. It's not that we can wait for a, my lord, that selection is over in 2020 itself. Now we are in 2025. Now this particular document has been issued by the SEBA authority subsequently.
Confirming the her date of birth.
My lord, when, my lord, this particular, whatever, my lord, that tempered document was there, it is not before this honorable court. Now we can at least verify that whether that one and this one is same, my lord. Of course, there some record will be there in SEBA. They have issued it accordingly. Whatever was there in their record.
Her date of birth.
Here
27.
27/12/75. It has been mentioned here as 27/12/75.
In the duplicate copy of her certificate also, it has been mentioned.
That perhaps, my lord, since it has been lost by the petitioner, whether, my lord, we can rely upon any document, my lord.
So, can you again re-examine the matter? Document?
Even if we re-examine, my lord, the selection is over. That's why I'm saying, my lord. Regarding
Is there any books or line taken?
from 2020 as on date, my lord, even if some post was lying in the next election, it will be over, my lord. That's why I'm saying, my lord.
Next election?
Means from 2020 till there are other selections too, my lord. Or, my lord, somebody else will be appointed, my lord.
No,
And it's not that she was selected
no.
for appointment,
Mr. Gogoi, you say
my lord.
you obtain inspection whether.
Yes,
the
otherwise she was eligible, she would have been appointed or not, my lord, considering her merit and whether any vacancy is there or not.
Yes.
Because he will have to come within the zone, my lord, because whoever has been appointed, say from 1 to
Yes.
100, if on merit he goes, he would have been otherwise appointed. Then, of course, my lord, that's a different issue.
Yes. No, you examine her document now.
Lordship.
And also you obtain inspection with respect of any vacancy.
Of 2020, of that advertisement, my lord.
Yes. And whether she can be accommodated in any other post of contractual officer.
That I can otherwise have. Provided she comes with that, lordship will record that.
That's all right.
Merit if she comes because of these anomalies, my lord, she is deprived.
Mr. Gogoi, first they obtain inspection and there.
Vacancy, that I can have.
We will not pass any order.
Yes,
We keep the matter pending for inspection.
lordship.
Part Mr. L.R. Mazumdar, Garnet of the product. E. Gogoi, Garnet is something else. And it's a raw for, that's respondent number 6, respondent number 6. List the matter.
After 2 weeks, it will be after the vacation index.
Is already more than 7 years left.
Then lordship will post in, my lord, before vacation in the last week in that case.
Yes.
Was 25th or 24th. At least I will try 24th. 23rd.
23rd. So as to enable Mr. Gogoi to obtain inspection to whether the petitioner will come under the zone of consideration.
Yes.
And also whether any vacancy is there
Lordship.
to accommodate the petition. Please record.
My lord, I am obliged.
Obliged.
May I please, your lordship? My pleasure, Lordship. Lordship, last Friday, we have received an opposition from respondent number 3, Lordship. 3 weeks time may be given to file reply, Lordship.
Yes, Mr. Das, you have filed your affidavit.
Yes, my lord.
When?
5th of September, my lord.
You have received a copy,
Yes, I have received on 5/9/25.
so you want to
Right.
respond to the same.
Yes, Lordship.
Or that,
D. Burua.
the Borua, learning product. Or Das, learning
I'll be appearing for 1, 2, and 3, my lord.
1, 2, 3.
I'm for network paper. US for
Okay.
US for network five.
That's number 5. Mr. Das submits that he has already filed his affidavit in opposition. At this point, Mr. Borua, learning court of it may be granted huge time to file his response, the file his reply to the affidavit in opposition filed by Mr. Das, learning counsel for the response. There is accordingly allowed. That's the list of after dates.